All right. All the persons having business before the honorable appropriate judges, now I'm going to the Court of Appeals, from there and give your attention. God save the United States and the Honorable Court. This Honorable Court is now in session. Please be seated and come to order.
Good morning, everybody, and welcome to the District of Columbia Court of Appeals. We have 3 cases on this morning's regular calendar. And the first one, we have one party who is appearing remotely. So I will call the first case. It is Theodore Albert NELBACH, hopefully I'm saying that right, versus WILLOW NELBACH, number 22 CV 200. Ms. Nathanson, are you ready?
Your Honor, I am. May it please the court. Your Honors, Anna Nathanson for appellant Theodore NELBACH. I request to reserve 3 minutes for rebuttal. Mr. NELBACH requests that this court review this case de novo and reverse and remand the trial court's decision for 2 reasons. First, minor and temporary tax arrears during a pandemic where tax sales of occupied parties are barred is not waste. Second, equitable remedies are the appropriate and precedented remedies to balance the interests of the life tenant and remainderman.
So, counsel, the way you framed the argument is very fact specific, right? And that's one way to look at this case, but we're interpreting a statute. This may be my first time interpreting a statute written in the 13th century. So that's fun. But is it your position that this statute allows for or covers unpaid taxes as waste in some circumstances, but just not this one? Or is your interpretation of the statute something else?
I think the best reading is that it does not cover tax arrears in general. I think there's also, if you look at how some other jurisdictions have handled it, tax arrears at this level would not be covered under it. But I think on the whole, tax arrears are not covered by the statute of Gloucester.
Can I ask you, the phrase tax arrears could cover a variety of situations. And so imagine a situation that is beyond mere tax arrears, but got to the point where there had actually been a tax sale. Would you think that allowing the tax arrears to get to the point where there is a tax sale that at least for at that point extinguishes the remainder interest, that could constitute waste? Or do you think that even an actual tax sale would not constitute waste?
In the District of Columbia, after a tax sale, there is a whole year period to redeem the property if you pay off the tax arrears. So in the District of Columbia, at that point, you wouldn't necessarily have the permanent injury required for waste. However, other jurisdictions, or at least Massachusetts, have found the recording of a tax taking to be the appropriate situation to find waste. However, here, there was never a risk of a tax taking.
Can I ask you, in answering the last question, you referred to the idea that there would have to be like a permanent injury for something to constitute waste. And I guess I have 2 questions about that, so apologies for them being multiple, but one of them is, where do you find that in DC law, or are you relying instead on general principles of the concept in a common law concept of waste? And second, is it really accurate? I mean, imagine that I have a life interest in property and you have a remainder interest, and I cut down all of the trees. Well, let's say that trees will grow back, so it's not permanent. It's definitely, it could be very detrimental to the remainder interest in the lake, but I don't know that it would quite be permanent. So just wonder if you can answer both, the kind of precedent question and the practical question about whether it really should have to be permanent to be waste.
For the permanent nature of waste, that's from a general principle. There's not that much in the District of Columbia defining waste in a way that was relevant.
A general principle that comes from where?
In this case, it comes from 93 CJS waste.
And what do you think about the hypothetical where someone who holds a life interest, completely deforests some property? Do you think that's not waste because trees grow back eventually? It might take, decades, but they eventually grow back. Or do you think permanent might be an unduly restrictive term, at least in some settings?
I think the distinction between that scenario and this one is, trees take decades to grow back. Tax arrears can be paid off at any moment, and just taxes being past due does not approach anywhere near a permanent situation.
You referred also to equitable remedies short of waste that you believe Ms. NELBACH had available to her. And I guess I'm interested in one aspect of that. Does your client concede that he has a legal obligation at least to make Ms. NELBACH whole for the tax arrears that she paid to bring the property current or more current in taxes and to forestall tax sale, which may have, again, not have been feasible for other reasons, I know you say, but what's your position about the extent to which your client has a legal obligation to make Ms. NELBACH whole for those payments?
First, we do not believe her payment did not forestall tax sale because there was an exemption in place for the occupied property. There was never a risk of a tax sale. That fact is significant because she was not under duress to make this payment. If you look at how other jurisdictions handle this issue, California found that a payment of this type towards the tax sales by the remainderment is a gift, even though in the case Huddleston v. Washington, the taxes were about to go into default. The remainderment's payment was found not to be made under duress. So
I thought, wasn't it in the answer that there was a concession that Ms. NELBACH should be repaid?
no.
Mistaken about that?
I believe there in the answer, Mr. NELBACH agreed that she had made that payment.
My recollection.
I believe he says in his answer, I will pay what she is owed, and accordingly, this will make all relief moot. And I further ask that the rest of the relief be denied. So do you think that you're not bound by that response?
That was in the pro se answer. So we tried to move away from that in the opposition after reviewing the law and seeing that properly should be treated as a gift. I think
Did you brief that in the trial court that this was a gift? I didn't see that argument in the summary judgment briefing.
I may not have.
Sorry, I wasn't sure if you were still answering that question. Can you, the gift case that you mentioned, was that did you say it was California or state of Washington?
That was California, and I also cite to a similar Tennessee case.
Okay, and were the circumstances in that case, did they have the main aspect of this one where the person who in that case, I guess, was providing a gift was paying off taxes to prevent foreclosure?
I think in this situation, the remainderman was not paying off taxes to prevent foreclosure. However, in the California case, the taxes are about to go into default, which would have started to trigger tax penalties as well. So yes.
So can I just get an answer on my question about what was or wasn't argued after your client answered the complaint? Do you think that you teed up an argument about this being a gift? I see what your argument is, that you're saying she is not entitled to summary judgment. So maybe this is some downstream argument that remains to be made if summary judgment were vacated, but I don't see an argument in the summary judgment pleadings. I don't see any movement away from the concession and the answer that this was that he owes Ms. NELBACH.
You're correct.
Relatedly, I recall, though right now I'm having trouble locating it exactly in the record, that Ms. NELBACH also alleged, leaving aside what was said in the complaint, that she alleged at some point that Mr. NELBACH had promised to pay her back for the taxes. Do you know whether that is accurate? And if it is accurate, do you know if that allegation was a disputed fact for purposes of the summary judgment filings?
That I don't believe that was a disputed fact for the purpose of summary judgment, and I don't recall anything in the record about Mr. NELBACH's position on that.
Do you think procedurally, assuming for a moment that this court or the trial court or some court would conclude that there had been an allegation of a promise to pay those, to compensate Ms. NELBACH for those taxes, and there had been a concession of a willingness to do that, and that matter hadn't been disputed in a way that would leave that really open. Do you think that is a remedy that it would be otherwise appropriate to enter in this case, in the sense that, I mean, the complaint did request, a determination of waste, but also requested such other relief as is appropriate. And I'm just wondering whether you think that whether you have any additional procedural objections to if the other matters were resolved unfavorably to your client, to an order in this case that would end up requiring your client to pay the to compensate Ms. NELBACH for the tax payments.
Well, Your Honor, in Elliott v. Lamon, the equitable remedy the court used was to order the life tenant to pay the tax arrears within 30 days before further penalties would be triggered. So repaying the paid amount to the remainderman might be akin to that. So under DC precedent, I think that would be a fair reading. However, other jurisdictions have asked us to look closer at if this payment was a gift or not, given that ahead of time the life tenant did not come to any agreement with the remainderman that she would be repaid for this amount.
We've been talking about whether or not tax arrears could be or is waste under the statute. If it were waste under the statute of Gloucester, do you think that there is discretion in the remedy under the statute? Do you think that, in other words, do you think that forfeiture and treble damages is required in every instance of waste?
No, certainly not. Across the United States, all courts have construed the statute of Gloucester statutes very strictly and have not applied it to tax arrears issues.
I'm going to stop you right there, because my understanding is that we stand alone in having the statute of Gloucester in its precise wording from 1278 on our books. There is no other jurisdiction in the country that has not altered this language. So I guess I'm wondering, on what basis would you say, do you have a textual reading that you think that this statute is permissive in remedy versus mandatory? Looking to other jurisdictions doesn't seem helpful because no other jurisdiction has this language.
I think other jurisdictions have the most significant language within the statute, which is the commit waste language here in DC Code 42-1603, the waste committed by.
Right. You're getting that language, sorry to drill down, but you're getting that from 42-1603.
Yes.
That statute doesn't seem applicable to this situation. I thought we were under 42-1601. Right, if I'm reading 42-1603 correctly, but it's difficult to read Middle English. It seems to be talking about when you have a tenant or a life tenant who is then provided another, life tenancy, or, created another sub tenancy. And then what do you do in that situation with waste, right? But that's not what we have here. We just have the one life tenant and the remainderman. And so it seems to me that we're squarely under 1601. Why do you think we should look at 1603?
Well, those statutes have been raised together in this case, and they're kind of paired with how waste is to be dealt with. So I think they can both give us.
Why? I know that you have paired them, but why? Because it seems like 1603 is directed at something else than what is presented in this case.
I think the remainderman was initially seeking recovery under both.
Okay. Do you agree then that 1603 seems not applicable to this circumstance?
I agree.
Right. I mean, it's got a very long introduction of, because that diverse people in times past have let their lands and tenements to diverse persons, blah, 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 blah. But it's all about life tenants who then create sub tenancies. And we do not have that situation here.
Relatedly, if we assume that we are under 1601 rather than 1603, the wording, assuming that lease in the old language means lose, which is what I'm inferring, the old language does have a pretty mandatory ring to it. It seems to say that if you are attainted of waste, you will lease, I think meaning lose, the thing that you have wasted, and moreover, you will recompense thrice so much as the waste shall be taxed at. The shalls there make those pretty draconian remedies seem to be mandatory. Do you, is that how you read 1601 if it applies, or do you read it differently?
I read it differently. I do think we can look to how other jurisdictions have evolved the statute of Gloucester. I'm not sure the minor change, the changing in the wording they may have used changed the meaning. I think this permissive versus voluntary waste distinction has evolved as in the United States common law and in US courts as they have applied these statutes.
Just to interrupt for a second, with apologies, we may be talking at cross purposes if the word permissive, if you're focused on permissive waste versus affirmative waste, which is not the opposing term as I recall, but that's one distinction about what kinds of things constitute waste. The questions that Judge Easterly and I have been asking about 1601 are about whether the remedies, if there is waste, so assuming whether it covers permissive waste or doesn't or whatever, if there is waste within the meaning of the statute, whether the remedy is mandatory or instead is within the discretion, kind of equitable discretion of the judge. So I think that I was speaking for myself, and my understanding of Judge Easterly's questions was we were asking about a kind of a different aspect of permissive, which is assuming there's waste covered by 1601, are the relatively harsh remedies of loss of the interest and forfeiture of the interest and treble damages, are those required, or does a court in equity have discretion to impose them or not, depending on what would be fair?
Thank you, Your Honor. I believe a court at equity still has discretion. If you look at other jurisdictions like Minnesota, Bellevue, there is a statute of Gloucester-based statute on the books in Minnesota, but the court still did not apply that to a permissive waste situation and still applied an equitable remedy where the life tenant was to receive proceeds from the sale. So I believe we see other courts choosing not to apply those severe remedies.
But how do you justify that textually? Would you say a court could just say double damages or just single damages, so shall recompense once so much as the waste shall be taxed, even though the statute says shall recompense thrice?
Other jurisdictions have chosen not to apply the statute of Gloucester at all and instead turn to the equitable remedies they have developed in their jurisdiction.
Well, thank you very much, Ms. Nathanson. We've taken up all of your time, but we will give you some time for rebuttal. Let's hear from Mr. Bateman.
Good morning, judges, and may it please the court. My name is David Bateman, and I represent the appellee, Willow NELBACH, in this case. Judges, I think at the outset, I think it's important to frame what's really before the court. There's really two questions. And the first is, does the failure of a life tenant to pay tax constitute waste in the District of Columbia? That's the first question that I think the court has to answer.
And do you think that's an open question, or do you think we're bound by precedent?
I think Elliott versus Lamont takes care of that question completely.
Why?
Well,
and I'll be more pointed. It doesn't cite to the statute, and it never uses the word waste.
yeah.
So for sure, it recognizes a duty to pay taxes, but I don't see that as the question here, right? I don't see Mr. NELBACH disputing that he has an obligation to pay the taxes as a life tenant. He's not saying, go take a hike. I don't have any obligation to pay any taxes. I'm a life tenant. I can enjoy this property, and somebody else has to pay the taxes. That's not what he's saying. He's saying my tax arrears are not waste, and I don't see Elliott speaking to that question, and I wonder why you think it does.
Well, I think there's a couple of reasons, and I'm just let me touch on one of the first things that your question raises very briefly. So I'm gonna kind of reverse the order, which is, why is the statute not cited then? These statutes really came about in the earliest 20th century. The earliest enactment of this statute that I found in the District of Columbia was in 1887. If you look at Elliott versus Lamont, that case is, I think, 1874. So it actually precedes by about 13 years in which the courts of equity may have been dealing with these kinds of things. The second question, Judge
Well,
Easter.
they almost certainly were, right? I mean, if the statute in 1887 is codifying the common law of waste, then for sure they were. And I understand. I mean, I was looking at both of your cases. You cite to Elliott and Atkins and say they decide this question. Atkins is from 1906, also doesn't cite a statute, I don't believe uses the word waste, but Elliott pre-1887 just doesn't talk about the concept of waste, which is, that's the whole question before us. So
Well-
how one could rely on a case that recognizes a duty to pay taxes, but doesn't speak to the concept of waste, I don't see how that could be binding precedent on us to say that a tax arrears is waste under a statute that doesn't exist yet.
Well, Judge, there's no question that the duty exists, and I think Elliott versus Lamont encapsulates that. The question then for the court is, well, how do we characterize that duty? In other words, what is the claim of action that a remainderman would have when his life tenant fails to pay that? There's no general breach of duty to pay tax, at least that I've been able to see in the District of Columbia. Other cases routinely, including nearly all of the cases cited here, the Madison.
You don't think a person could go into Superior Court, a court of general jurisdiction, and say, this life tenant has a duty to pay taxes, see these old cases, and I want injunctive relief. I want the appointment of a receiver, or I've paid the taxes and I want to be reimbursed. I have a cause for unjust enrichment. You don't think that that's, I mean, that seems completely clear that somebody could do that, could avail themselves of those types of remedies.
I absolutely
separate and apart from trying to pursue a claim for waste.
I absolutely agree with your honor that somebody could do that. And I think exactly the way the Superior Court would treat that, whether the individual litigant addressed it as waste or not, is I think the Superior Court would address it as a waste claim.
But no, I mean, that is the question, right? Because the remedy, I mean, what you get if you characterize this as waste versus just a cause for damages, right? Is you get forfeiture of the property and treble damages. I mean, it is, as my law clerk said, the nuclear option, right? And seems potentially, and certainly in this case, completely disproportionate. I mean, I have no idea how much the value of this property is, but right, at no time did the tax arrears in this case exceed $10,000. And if one assumes that pretty much all property in the District of Columbia is valued, 10 times $10,000, because it's very expensive to live in the District of Columbia, requiring forfeiture of the life estate plus treble damages, I mean, that is just draconian.
Well, Judge.
And so that is the question, is why should we characterize this as waste versus saying, look, your client has a remedy. It's just not under this statute. This statute is for, when the property is just destroyed, right? The trees are cut down, the streams are polluted, just the property is destroyed. And that is not this case.
Well, I think my response would be twofold to that. The first is whether or not what this action was and in this case, it's the failure to pay taxes. And understand, this isn't a devalue of the property of $10,000, as your honor noted. This is an absolute loss of the title interest in the property through foreclosure. In other words, the remainderman's interest in the property through the foreclosure goes to zero. It doesn't go $10,000.
Wait a second. I mean, I'm not sure that that's true, right? I don't know that the district could foreclose on the entire fee, if I'm using the traditional property terms. Like, I think they could foreclose on the life estate, but what is your authority for saying that they could foreclose on the entire title to the property?
Well, I would just, first of all, refer your honor to one of the cases that I cited where that was the exact argument made. And that's in that and I understand it's a Massachusetts case, but the Madison versus Walsh case, that was exactly the argument
I
made.
just find these citations to other jurisdictions' cases to be unhelpful because we have, really particular procedures in the District of Columbia for how these tax sales can operate. So setting aside, let's assume that a tax foreclosure of the entire interest in the property is possible. Let's just drill down into these facts, right? In 2021, when your client filed a waste action, the prior year, 2020, the year of COVID, all tax sales, which happen annually, had been canceled. So there was no possibility of a tax foreclosure sale the year prior. Turns out all tax sales in 2021 were also canceled. No possibility of a tax sale foreclosure in 2021, right? And your client came in and paid a sizable amount of the tax arrears such that the arrears fell under the statutory limit that has to trigger a tax sale. So as of, I believe, August 2021, the tax arrears didn't satisfy the $2,500 threshold to trigger a tax sale. So at the time your client moved for summary judgment, it was not possible to have a tax foreclosure sale with respect to this property.
Well, Judge, I don't think the question arises at the time of the tax sale. The question is whether the life tenant had wasted the property at the filing of the action. And the answer to that is,
to be clear, if that's right, then imagine that I own I have a life interest and you have a remainder interest, and I have the obligation to pay the taxes. And the day on which I'm supposed to pay the taxes passes. So I'm now in arrears. And the next day, and I'm 2 days late. And the next day you file an action and you say that's waste. There are tax arrears. This could end up in a tax sale that could foreclose my interest. You say, absolutely. I'm interested in discussing that too. But am I right in understanding your view that as a matter of law, that's waste? That happens right then, and it doesn't matter how minimal the arrears are, how recently they have arisen, how unlikely it is, or maybe even legally impossible that there could be a tax sale based on the arrears in that amount. It's just the mere fact of arrears as a matter of law constitutes waste. That's what it seems like you're saying, and that seems like a tough hill to climb.
Judge McLeese, I would agree with only part of your scenario there. That part of the scenario is, I think your question poses what is it waste? Is it the $300 or $500? Is the amount the waste or the timing the waste? And that's not how I think this court should define waste. The way that the court should define waste is defined by when the tax arrearage is such that it threatens the remainderment's interest.
But how do you quantify, how much of a threat is, because this is wrapped up in these hypos too, how much of a risk or a threat of disclosure how clear does it have to be? Is it just any risk at all? Or does it have to be a real risk? Or, how would we talk about that?
Look, the test that I would propose this court is that if a reasonable remainderment has to take action in order to step in to protect that interest somehow, either from being devalued or from, in this case, quite frankly, potentially being lost, then I think that is waste.
Okay, so it would seem that then the arrearage has to be over the threshold, right? So if I underpay my taxes for 5 years by $5 every year, right? I'm in arrears. There's an automatic lien for $25, right? Because I've underpaid my taxes consistently by $5, right? But you would say that's not waste because that doesn't threaten the remainderment's interest because it can't trigger a tax sale. Is that correct?
I wouldn't. Yes, I think that's right. I think the amount again isn't necessary, which is I think what your honor is talking about. The question
Well, it's
here.
got to be necessary. If there's a statute that says that you cannot trigger a tax, right? I mean, I guess what I'm hearing you say is there's something inherently dangerous to the value of the property by the mere existence of a lien, right? And I just want to push back on that, right? Because, okay, I haven't paid my taxes for 5 years by $5. There's a $25 lien. But how does that threaten the value of the property in any non-speculative imminent way, right? I'm a life tenant. I cannot sell the property, right? So I cannot sell the property at a loss, that accounts for the $25 lien, right?
Right.
You get the property after my life tenancy ends, but who's to say I'm not going to pay the $25 back? Right? Like, so it's completely speculative, and there's no the existence of the lien, it seems, in this circumstance cannot be enough to be waste. There has to be the real danger of a tax sale.
Well, Judge,
Do you agree or disagree?
I absolutely agree with
Okay,
your hypothetical. And let me just define the point as to why your hypothetical is absolutely correct. The lien itself, I agree with you that the lien itself is not the waste, not alone. In other words, there has to be some triggering action that threatens the remainderman's interest. In this case, it's the DC department sending out a notification that,
okay,
hey,
let me stop you there.
Okay.
Right? Okay. So there has to be some real danger of damage to the property, right? And you're saying the lien is not enough. But what I hear you about to say is the notice of delinquency tells you that.
That's right.
Let's look at the notice of delinquency. The notice of delinquency says, this is a notice of delinquency, failure to pay taxes immediately may have serious consequences, which may include the loss of the title to the property. To avoid a tax sale, you must pay this amount by May 31st. And then it says, but if you pay after May 31st, you just have to pay a little bit more, right? And then there's the notice of outstanding liabilities that says, well, if you pay by April, you pay this amount. If you pay by May, you pay this amount. If you pay by this later date in May, you pay this amount. If you pay in June, you pay this amount. It seems pretty clear from the notice of delinquency that all is not over if he doesn't pay by May 31st. And in fact, that's the law, right? The district cannot, on this single notice of delinquency, schedule a tax sale, right? They have to send another notice of delinquency 2 weeks before the actual tax sale per statute. So this cannot be the end of the game.
Well, Judge, let me address that concern in two ways. The first point that I want to make is, I think that the court has to look through this through the eyes of a reasonable person. When a reasonable person,
A reasonable person needs to read the law, right? And the law is there cannot be a tax sale on May 31st or June 1st, right?
I don't, with respect, I don't agree with the court's question there. I agree legally that is the case.
The notice of delinquency says you can pay in June. You're just going to have to pay a little bit more.
It also says that if you don't pay by May 31st, the property may be exposed to a tax sale.
May at some undefined, uncertain time.
That's right.
And please just pay us. And if you want to pay us in June, you just pay us a little bit more.
Well, Judge, the remainderman's in a position when they get a notice that says this is a property that may be sold at a tax foreclosure sale. And she then turns around and makes a demand on the life tenant saying, hey, I have real concerns, pay that tax. And the life tenant says, no, thank you.
Can I ask you to go even a little bit further, because we've been assuming, just for the sake of the discussion, that, well, okay, but if there was a real risk of a tax sale, then maybe that would be waste. And in connection with that, I think you at one point referred to the possibility that the remainder interest would be absolutely lost. And I do think that a tax sale can extinguish remainder interests, but Your opponent points out that DC, and probably a number of other jurisdictions too, but DC in particular has very generous tax sale redemption provisions. And so if you buy a property at tax sale, if you think you own the property in any normal sense of the term, you definitely don't. There is a long process with many opportunities for people who have an interest, including people who have life interests and remainder interests, to redeem the property. And so one wonders whether there's really, even if there is a tax sale, like an unavoidable threat to the interest of the someone who holds a remainder interest, given the ability to redeem. Now, I understand that would impose costs on the remainder person, but would you agree that just, let's say this had gone all the way to a tax sale, that would not have irredeemably extinguished your client's interests?
There's certainly a redemption period and some other things. So I certainly agree with that characterization. Let me, and with that, I want to connect, if I could, just to the last part of Judge Easterly's question, because I think it helps answer this question, which is, I don't think that that's an issue that this court even needs to grapple with. And one of the reasons why is because if you look at the complaint and the answer, it's effectively already been admitted for this court.
What has been admitted?
Well, that the payment was made specifically for the purpose of avoiding a foreclosure sale. That, if the court looks at the appendix at page 4.
I'm sorry, that just seems a little too cute. He's clearly saying this shouldn't be waste. Don't make me forfeit my property. I'll pay her back.
He's, Judge, in that he's arguing with the remedy, which, by the way, he didn't raise in his opposition to the summary judgment.
Okay, this is a pro se answer, and I think holding Mr. NELBACH to some sort of concession that this is waste in this answer would be unfair and an extreme. I don't see a concession, a legal concession in this answer.
Well, Judge, again, I'm just pointing to paragraph 22, which he admits. And by the way, this isn't a pro se.
You're not looking at the answer. You're looking at his responses to the statement of undisputed facts.
No, I'm looking at the complaint, paragraph 22, and then his answer.
Well, even if it's true that he conceded, there was a concession that your client's subjective purpose was to avoid a foreclosure sale, I'm not sure that answers the question of whether there was waste. That may suggest that your client thought that there might be circumstances that got to waste, but I don't know that that means that that's a concession that, oh yeah, actually they were necessary to avoid a foreclosure sale, rather than that was their purpose subjectively in the mind of your client.
Well, that may be, I think it's a second reason for the same argument. But what I
can ask you another question too, because you're sort of, part of your point seems to be, look, in fairness, your client holds a remainder interest. She's concerned. Even if you think, okay, maybe I could redeem it at a tax sale, that's a lot of burden, and she's reasonably concerned. I 100% hear the idea that she's reasonably concerned, but it seems as though she might have remedies short of waste, which I'm interested in discussing your view about how mandatory and draconian it might be in terms of the remedies. And it seems as though she could go in and file an action along the lines of Elliott that would be in the nature of saying, look, I hold a remainder interest. The holder of the life interest is legally obliged to pay the taxes. He has not been paying those taxes. I have demanded that he do so. He's failing to do so. The ultimate consequence of that could be, a process that at the upshot of which would be that I would lose my interest. And therefore, I want you to grant the kind of remedy that was granted in Elliott, which is issue an order essentially directing payment of the taxes and on pain, perhaps, of harsher remedies. At times it seemed as though you were suggesting that there can't be an action like that unless the failure to pay taxes itself is waste. And that just doesn't seem to me obvious. Is that your position, though, that your client, unless the failure to pay taxes is waste, there is no equitable remedy of the kind I was describing?
Well, I think the statute makes it clear what the remedy for waste is.
Well, my question is different from that. My question is, let's assume that payment, that failure to pay taxes in circumstances like this case, and maybe ever, because of the possibility of the right of redemption, is just not waste. Do you think that someone who holds a life interest, who's concerned about the adverse consequences of a failure, holds a remainder interest, who's concerned about the adverse consequences from the life interest holder's failure to pay taxes, has an action in equity to try to ask a court to issue an order directing the holder of the life interest to pay the taxes on the property issue? That's my question.
I suppose that a separate action of some kind, which as I stand here today, I don't know what that is. As I indicated to Judge Easterly, I think the action of waste is the appropriate action under those circumstances. And why do I say that? I say,
so I'm not quite sure I got an answer, yes or no, to my question. So just to make sure I understand, it sounds like you started to seem like you were going to say yes, even if that isn't waste, there would be an action of that kind. But then you seem to pivot to actually waste is, you know, the only game in town. So I'm just not sure where your bottom line answer is. Do you think waste is the only game here? And so, you know, again, I mean, so let me give you a hypothetical. Imagine, let's get out of tax sales, which are complicated. And let's say I own a piece of land. I have a life interest in a piece of land and you have the remainder interest. And I tell you, you know what I'm going to do? I'm going to cut down every tree on this property. And you say, you can't do that. That would be waste. And I say, I don't care. I'm going to do it. And you don't want me to do it. And you don't want to wait until I do it and then bring a waste action, although it might be in your interest because then you could get the property and treble damages. But let's say you don't want to do that. And so you go into court and you file, you know, you ask for a declaration and injunction to prevent waste. Don't you think you could do that?
I do think that I do think that there's injunctive relief.
And wouldn't
that
this
would
be the
be
same?
available.
And wouldn't in a tax sale the same kind of relief be available? Which is you go in and you say, this is going to end up at waste. If it goes on forever, there might get a point where this would be waste. Let's stop it now. Let's enjoin what is, what seems to be imminent or prospective waste.
I concede that an injunction would be an available cause of action under those circumstances.
And can I ask you, this shifts over to another part of your answer. We discussed with your colleague the question of whether the remedies in 1601, if that's the applicable provision, are mandatory. And I wanted to make sure I got your position on that. So again, if this is waste, is it your view that there's no discretion on the part of a trial judge to grant relief other than both treble damages and extinguishment of the life interest holder's interest?
That's right. And the reason why, Judge,
is that based on the text?
It is.
So can I ask you a question about the text, right? And as Judge McLeese noted earlier, right, the language is, he which shall be attained of waste shall lease, meaning lose the thing that he hath wasted, right? And so the shall sounds very mandatory, but I think in other cases, this court and Supreme Court has said, well, sometimes shall means must, and sometimes it means may. And if you read the statute from the start, right, the beginning, the initial phrase is, a man from henceforth shall have a writ of waste in chancery against him, right? So do you think that shall is also mandatory? Like you have to bring a waste action against everyone who wastes your remainder interest, right? Like it's directive to the remainderman.
No,
you are under, statutory directive that you shall bring a waste action.
No, that's not how I read that.
And I don't read it that way either. So if that shall is merely permissive, is there an argument to say that the shalls throughout the statute are permissive? Or do you think the shall in the first part of the statute is permissive, but the shall in the later part is directive?
No, I don't think the shall in the first part is permissive. I think what it's saying is that the person shall have a writ of waste, shall have it. It doesn't mean the person
it's against him, right? It's saying It's saying who can be sued for waste. A
Right.
man from henceforth shall have a writ of waste in chancery against him that holdeth by law or otherwise for term of life or term of years, right? Saying that's who a defendant to a waste action can be, is how I'm reading it. But if
Right.
one thinks that shall is mandatory, then it could read as a directive to any remainder person to say, you have to bring a waste action against a life tenant, which it seems like an odd way of reading
I
the
don't,
statute.
if this statute had been written that a remainderman shall file a writ of waste against the life tenant, then I would agree with you that then we would have to say, well, that somehow has some implication of permissive. But the way this is written, this doesn't compel any, it's not, the way the first sentence is written is not compulsory toward the remainderman. In other words, the remainderman always has the ability to file or not file, but whether he chooses to prosecute that action, it is compulsory in that a writ of waste always exists against a life tenant who has committed waste.
Right. And so if a writ of waste always is an available option, why would you read the first phrase as saying it's an available option and not read the second phrase to say, and these are some available remedies, but not mandatory, right? I mean, the whole statute is written in the passive.
It is. And Judge, I think one of the reasons why, and this kind of gets back to one of the things I was going to talk about with Judge McLeese, is you have to look at the history of how this statute was applied and the purpose of the statute, by the way. The whole purpose of the enactment of this statute was landlords this goes back to the 1200s, I understand, but I think it's relevant in the DC Council passing the statute, which is people were abandoning.
I'm not sure it was the DC Council. But.
Well, I apologize, but a landlord, his tenants were abandoning their interest in the property, and there wasn't a proper remedy. And so this is the remedy they chose. And
I'm not actually sure that's historically correct. I mean, just based on what I've read, it's not necessarily about abandonment, right? It's about life tenants sucking all the resources from the property and leaving nothing for the remainderman. And that was the concern, right? And there seemed to be in 1278, not a whole other, not a range of options such as there are now, right? And, the fact that this is imported into our law in 1887, seemingly with not a lot of thought, because they imported references about remittances to the king at the same time. And I think we had been independent from England for at least 100 years at that time. So I'm not sure what they were going to do with those remittances. But I'm trying to figure out, like, how does that map on to the concerns that undergird this statute in 1278? How do they map on to the situation of tax arrearages in the District of Columbia in 2021, right? And it seems like it's just a totally different landscape. So why would we say that a tax arrearage is waste, or if it is waste, that it mandatorily triggers this divestiture of a life estate and treble damages? It just seems completely out of sync with the modern reality. And I'd really love to hear why you think differently.
Yeah, I think a couple of things. The first thing is just a policy issue. The point that I was going to get is the policy issue of the statute. The statute of forfeiture and treble damages, I understand that's a penalty, right? It's a harsh statute. I agree with that. So what's the purpose of it? Well, a life tenant holds, almost as a trustee, almost as a fiduciary duty, the property for the benefit of his remainderment. And so the purpose of the statute is to dissuade a life tenant. Judge Easterly, you rightly pointed that a person needs to know the law. They're charged with knowing the law. The law is, this particular law has never been repealed. It was reenacted in the 70s. It was reenacted in the 80s. Through the reenactment, it's affirmed. Why? Because we don't want landlords wasting the property of the life tenant. And in often cases, for example, in this one where you have maybe a small arrearage or something like that, relatively small, I suppose, we don't want a tenant.
I think we're sort of talking past each other. Yes, we have a waste statute on the books. Yes, we want a waste statute on the books. That's why it continues to be on the books, even in this antiquated language. The question is, what purpose is it serving? What does it mean? We've never interpreted it, right? There's no case from this court or our predecessor court interpreting this language, much less saying that a tax arrearage in the context of how tax arrearages are handled and how tax sales are held and what the rights to redeem are is waste. So yes, something that constitutes waste, we want to be, we want the remainder person to have the remedy of forfeiture and treble damages. But why should we interpret this statute to include tax arrearages given the legal landscape as it exists in 2021 in the District of Columbia? Because
the statute on its face applies. There is no exception, Judge.
The statute on its face does not say anything about tax arrearages. It just says waste. It does not define waste.
That's right. And so the box.
And that is why we are here. And I'm trying to figure out why you want me to tell, why you want us to hold that waste should include tax arrearages given the legal landscape in the District of Columbia in 2021.
The answer to that question, Judge, is simply the way this court defines waste. In the Superior Court determined that it was. And this court, I agree with this court that the question is whether or not the taxes constitute waste. If the answer to that question is
yes. The Superior Court in this case didn't even get the amounts right about what the tax arrearages were and who had paid what. So relying on the Superior Court's analysis in this case is not going to be an adequate answer to why we should look and interpret the statute in the way that you want us to. It's just, that's just not responsive. So I'm looking for something a little bit different.
Before we get to the statute, and I think that your Honor has framed it correctly, before you get to the statute, the question is whether the failure to pay taxes in the District of Columbia constitutes waste. That particular question, depending on how the court defines waste, and I think universally, I think almost every jurisdiction is going, and I understand that you're not bound by jurisdiction. My proposed test for this court would be the same as that's contained in the restatements, for example. And if you look at how waste is defined in the restatements.
Are you looking at 199? Right. 199 of the restatement says that we allow forfeiture, or most jurisdictions in 1946 allowed forfeiture for waste based on affirmative and voluntary acts that diminish the market value of the property. And it needs to be malicious and of such an extent that the damages are equivalent to the value of the unexpired portion of the estate for life.
Well, I certainly wouldn't agree with that.
That's 199 of the first.
Well, I believe it's 129. Let me.
129 doesn't talk about waste. 129 just talks about the duty to pay taxes and then lists a number of remedies to make sure the taxes are paid or that the remainder person gets repaid, and it doesn't include forfeiture.
All right, let me, Judge, I actually don't have that in front of me and I apologize. So let me cite one that I do have in front of me, which is 78 American Jurisprudence 2nd, Waste, Section 1, 1975. And this is what that holds. Waste is the destruction, misuse, alteration, or neglect of premises by one in lawful possession thereof to the prejudice of the estate or interest therein of another. In other
Can I ask
words,
you to just, we walked through this a little bit, but just, it would help me if I knew where you think the line falls. So let's leave aside some of the complexities that arise in this case because of COVID and pandemic and suspension of tax sales and the like. But in an ordinary situation, again, imagine that there is someone who, there's a holder of a life interest who has been paying taxes and should pay taxes, who then misses a tax payment. And imagine that the holder of the remainder interest flags that problem and says, please pay. And then imagine things start happening. So there's the immediate missed payment and request for payment. Is that waste in the ordinary course?
depending on the circumstances, alone on the facts that you've suggested, I would say no.
Okay, so then let's say there's a notice of delinquency filed that, has the language that has been under discussion that says, among other things, down the road, there could be a tax sale, but also says, if you want to get your property right with us, you could pay the following amounts at the following times. Has waste occurred then?
Again, I think it's going to be a factual determination, but I think
Depending on what,
but I think there, I would say almost certainly waste has occurred. In other words, if there is delinquencies that are going out that threaten the interest in the properity,
well,
then
in one sense, the moment I don't pay my taxes, if I'm the holder of the life interest, a threat. I mean, there's there is a threat depending on what happens down the road. So there
is, Judge, but there's no action that's being taken. In other words, just because there's a delinquency of your first tax assessment, and let's say that tax assessment is due on June 1st, and now we're sitting here on March 2nd and a delinquency notice goes out, the mere fact on January 2nd.
Just to make it clear, if I understand the line you're drawing, if I'm the holder of the life interest and I don't pay the taxes and you're aware of it, you check with me and you say, hey, the taxes were due on this day. Did you file them? And I say, no. You say no waste, but you say if a week later, a delinquency notice is issued and therefore no remedy for you other than maybe in equity an order requiring me to make the payment. But no waste, none of the more draconian remedies that arise from waste. But a week later, if a notice of delinquency is issued, then you would have an action against me for treble damages and a complete extinguishment of my interest.
I think depending on what that notice said, here's the problem.
We'll assume that it includes among the list of possible consequences of my non-payment, a tax sale.
Here's the problem, I think, with the question that we're grappling with is it's a fact-intensive question. In other words, as I proposed earlier, I think the test that this court ought to set is whether a reasonable remainderman thought or believed or that he had to take some action in order to protect his interest. And that's really where your Honor's questions are going with. How many facts do I need to add before I kind of kick that over where it's reasonable for the remainderman to say, hey, wait a second, something has to happen in order to protect my interest.
I don't think it's unreasonable myself for the remainder, holder of the remainder interest, if a tax payment has been missed, to say, look, I don't want to mess with this. I'm going to pay and I'm going to try to claw it back from you. And so,
sure.
If the test is it reasonable for the holder of the remainder interest to be concerned? I would say that is a reasonable concern the moment there is a failure to pay taxes.
But that wasn't my test to your Honor. My test to your Honor is whether the remainderman reasonably believes that he needs to do something. He needs to take some action.
So there's a subjective and objective component of not just I want the tax. I know the taxes are paid and I want them paid, which is sort of what Judge McLeese was saying. But you're saying that there's a subjective and objective appreciation that the property is endangered of tax foreclosure.
Yeah, I mean, I think that the remainderman needs to certainly believe that they need to do something. But I think there is
you said reasonable several times.
That's right.
Okay, so then is it reasonable if the notice indicates this is not the last notice you're going to receive? And in fact, under the law, it can't be the last notice. if no tax sales are allowed for whatever reason, COVID, or they've been suspended for whatever reason, like if tax sales are not allowed and the amount owed doesn't trigger the tax sale, right? Is it then reasonable to think this is waste?
Well, to be clear, Judge, the amount when that notice is issued is more than enough to trigger the tax sale. In other words,
My hypothetical, right? Any one of those things, would it be reasonable for me to think, right? So I guess what you're saying is, or this is where I'm losing you. Is it waste? So it's not waste as soon as there's a delinquency and a lien. It may be waste as soon as there's a notice of delinquency.
right.
Okay. But I'm saying if at the time the notice of delinquency issues, the amount owed is not enough to trigger a tax foreclosure sale, is that waste at that point?
I think that if the notice of delinquency, and I don't know if this, my answer to that question alone on those facts is I don't know. Here's where I think it would.
It's got to be a yes or no answer, right? Like if there's, I mean, if you cannot have a tax sale because the notice of delinquency shows that the amount owed is, less than what would trigger a tax sale, how could there be a reasonable concern that the property is endangered?
Well, if the notice itself says that the property is being subjected to a tax sale, or maybe
lists
then I
an
think,
amount $2,000
then
under the amount that statutorily triggers a tax sale.
I think that on an objective and a subjective basis would trigger a person to say, I have to pay the taxes to protect my interest.
Why on an objective basis?
Because the notice by DC itself, the DC government is saying.
Okay, what if the notice says what perhaps the remainder person should know and says, notice of delinquency, you owe $2,000. You may be subject to a tax sale. Please pay by these dates, as this one does. By the way, anything under $2,500 can't trigger a tax sale.
I think if it says nothing under, if the notice specifically said that the property, any amount under $2,500 would not be subjected to a foreclosure sale, I think certainly you'd have a better argument that is not waste, because but that's because a reasonable person, an objective and subjective person reading that notice would know that there's no threat to the property.
And so you don't think that a reasonable person needs to actually consult with the statute to see what the law is about triggering tax sales?
I think that a reasonable and objective person, Judge.
This isn't about whether or not she pays the taxes.
I understand.
This is about whether or not she has a claim for waste, right?
It's what, under my test, and I think that's what the court is pressing me on, is whether or not under those circumstances, a person believes that they ought to act. In other words, they ought to do something to preserve their interest. And
can I ask you whether one thing that occurs to me as I hear you is that you seem to be, collapsing is a strong term, I don't mean it in a critical way, but you seem to be introducing the concept of threat to the property, whereas waste tends to be like a thing actually bad happened to the property. And so let's say, for example, I get out of the tax sale setting, which adds complexities in my mind, and say again, I hold the life interest and you hold the remainder interest, and I say to you, I'm going to do some, I'm going to use some fertilizer or insecticides, and you say on the property, and you say, look, there's a very real risk that that's going to damage the property. I need to intervene. Well, you might reasonably feel you need to intervene, and you might reasonably feel that I'm threatening your interests. But if nothing bad has yet happened to the property, is that waste or is it just threatened waste? And that's where I get a little unsure. if all that has happened is, let's say in some of these hypotheticals, there is, there is a failure to pay and a lien, and then maybe a notice of delinquency, and then maybe a possible further notices of delinquency, and then maybe a sale, but still a right of redemption. All of those things you could say haven't damaged, at least up to the point of sale, sort of damage that could be fixed. Is that the right kind of damage? I don't know. But up until the point that there actually is a loss, a sale that extinguishes the interest, you could say there's a threat of damage to the remainder interest, but there hasn't yet been a damage to that interest, other than the lien, which I take you to not say is the right kind of damage.
Well, I think the diminishment in value does make a difference here. In other words, when it becomes actionable as waste might be a combination of those two. That's true. But let me Judge, waste oftentimes, and particularly permissive waste. Now, most areas there's not a distinguishment between permissive and commissive, as Ms. Nathanson wants this court to do. But what I would say is waste is often a process. In other words, let's assume that a tenant leaves a leaky roof. Well, the first couple of days, does the tenant, does the remainderman say, well, there's a leaky roof, there's not a lot of damage, so I just have to wait till it becomes big enough before I do something about it? And it gets bigger and bigger and bigger. I mean, at what point does the remainderman have to step in and say, no, you can't do that? And I think that the correct answer, because
again,
we're
remember that waste, I think you've acknowledged that waste and its attendant relatively harsh remedies is not the only option for the holder of remainder interest in that setting, because there's the ability to go in and seek injunctive relief and say, look, this is threatening waste, and I want you to intervene, court, and order the holder of the life interest to take steps to prevent waste. Let me just ask you, to give you one more chance, because I think one way of looking at some of the questions Katisha was asking you is, what's your best argument for why imposing forfeiture of the interest here and treble damages is fair, given what happened? So again, what happened is someone who has an obligation to pay taxes didn't pay it. There came to be a concern about whether there would be a tax sale. There's a dispute about how real that concern was and what a reasonable person would have understood about it. There, I think, is under agreement that if there had been a tax sale, there would have been a right of redemption that would have made any tax sale not irreparable. It might have been problematic, not cost-free, but not irreparable. So that's the situation. Why do you think it's fair that we, if we're trying to interpret the statute in part so that it operates fairly, why is it fair that at the end of that, the holder of the life interest should both lose the life interest and be subjected to treble damages?
Judge, the reason for the statute, here's my answer to that, because that's what the statutory remedy is. And there's a reason for that. There's a good reason for that. The first reason for that is to dissuade a life tenant from doing exactly to a remainderman is what happened here. The reason why that is, Judge, is because a life tenant is like a fiduciary. And I mentioned this before.
What's your cite for that? Because my understanding is that a life tenant, the life tenant isn't just holding the property for the remainder person. The life tenant has the right to use the property for their own enjoyment for the duration of their tenancy, right? And that's why we have the concept of waste, because, back in the 13th century, life tenants were allowed to farm the property and cut down some trees and divert some streams and do things that they thought were good for them while they had the property. They just couldn't go so far as to waste the property, right? Cut down all the trees, extract all the minerals, right? Like render the property unuseful after their life tenancy ended. So this idea that the life tenant is just holding it as a fiduciary, where does that come from?
Well, Judge, there's no other relationship. I think that the relationship is the most analogous in law to
I'm just wondering if you have a cite for that.
Well,
that
I have a cite from another church.
That a life tenant is a fiduciary.
Well, I have a cite from another jurisdiction that I'd be happy to provide the court. I don't know that that's helpful to Your Honor based on some of the comments about foreign jurisdictions. And if you want to give me a minute, I'd be happy to provide it to you.
I think that's the kind of thing that we can either, if it's in your briefs, we'll find it. If it's something that you haven't cited to us, you could provide it to us in a 28K.
I will provide it to you under, I believe it's one of the cases I've actually cited to the court, but I'm happy to indicate that in a letter, Judge. What I would say is that there are very few relationships in law where a individual is holding an interest, is holding possession of something that belongs to somebody else. Usually in the law, whether it's a bank, whether it's a trustee of a trust, and again, trustees of trusts have lots of discretion to do whatever they want with trust property sometimes. But they hold it for the benefit of somebody else. In other words, they're holding somebody else's property in their hand. And that's effectively what
Right. And I take issue with the premise that a life tenant is holding the life tenancy or holding the property for the benefit of somebody else. They have the life tenancy for their own benefit. That is the point of the life tenancy.
well,
Right.
but
There are limits on what they can do with the property, but the life tenant is not a fiduciary for the remainder person.
And that's the point, Judge, is that there are limits onto what they can do. That's similar, and that's why I compared it to a trustee who might have discretion under a trust to do a lot of things, but there are limits to what that trustee can do, how he can use the money, how he can do things, because in the end, that property that's held within the trust lands in the hand of the beneficiary. That's the point. And I agree, it's not a one, I'm not attempting to make a one-to-one comparison here, but I'm saying that relationship between a life tenant and his remainderment is the most analogous to a fiduciary relationship. Why? Because there are limits to what he can do. He can't just, take down all of the timber. Can the remainderman? Yeah, when it's in the possession of the remainderman's hand, the remainderman gets to do whatever he wants. There are no limits to what the remainderman wants, subject to zoning laws and other things. And so getting back, Judge McLeese, to your question, I think that's why the remedy here, that's why the statutory remedy is here. It's to just, is it harsh? Perhaps. Could the District of Columbia repeal it? Change it, modify it, perhaps, but they haven't. They've enacted it as recently as 1986. It's still on the books, and it's on the books for a purpose. And the purpose is to dissuade a life tenant from wasting the property that belongs to a remainderman. And, I understand that there may be parties on both sides of this case that, one party likes the statute, one party thinks it's too harsh. But the District of Columbia, if the statute is too harsh, there's an easy remedy for that. And that is to either repeal the statute or to modify the statute.
Thank you, Mr. Bateman. We've kept you up for quite some time.
Thank you, judges. I appreciate the time.
Ms. Nathanson, we will give you 3 minutes for rebuttal.
Thank you, Your Honor. Looking to Elliott v. Lehman, the statute of Gloucester was available at common law at that time. However, the court did not apply it to the tax arrears situation. That tells us that this permissive reading of the statute of Gloucester is correct. And the shalls are more like mays. Elliott v. Lehman is the precedent we have to work with here, and we see in that case that tax arrears are not waste for the purpose.
That may be reading more into the silence of that case. That may also just tell us that nobody who was litigating the case in the court focused on those principles of law.
That's fair, but if they actually had applied at that time, it would be likely that they would have been brought up. Furthermore, our understanding of if tax arrears are waste needs to be consistent with DC law around tax sales. and the specific procedure in the District of Columbia for how tax sales are conducted. The initial notice from the Office of Tax and Revenue clearly stated that there were exemptions from the tax sale that might apply. A call to the Office of Tax and Revenue would have revealed that during this global pandemic, there was an exemption in place for occupied properties at this time. And then there was the addition, and furthermore, even after a tax sale in the District of Columbia, you get a year of redemption. The law around tax sales being what it is in the District of Columbia, it is not proper to characterize the facts here as waste. For all these reasons, I respectfully request the court reverse and remand the trial to the trial court.
Thank you very much, Ms. Nathanson. And thank you both for your briefing and your arguments today. The case will be submitted. The second case on this morning's calendar is number 21 AA 653, ABERASH LLC, TA Signature Lounge versus DC Alcoholic Beverage Control Board. Whenever you're ready, Mr. Bianco.
Thank you very much. Don't mind indulging me for a moment while I get set up.
Of course.
I got so used to doing things in electronic realm, having trouble transitioning back to analog. I would like to reserve 3 minutes of my time for rebuttal if that pleases the court. My name is Richard Bianco. I represent the petitioner in this case, ABERASH LLC, which trades as Signature Lounge, a bar restaurant on Connecticut Avenue, Upper Connecticut Avenue Northwest. We are here today appealing certain conditions placed on the grant of their alcohol license.
And when, can I jump right in and say, when you say certain conditions, that is something that I'm kind of not sure I completely understand. Which conditions are you challenging at this point? The government says, I think you are just challenging the limitations on promoters. Is that accurate?
I don't think it is. I think we're challenging all 5 limitations that the board placed on the licensing. I think the briefing and notice of appeal demonstrates that. I think we did spend a lot of time focusing on the promoter issue. And I think we probably did that because it's the least related to the record and the facts of the case. Or at least there's no meaningful straight line between what the findings were and that particular remedy.
Yeah, well, can I ask you a factual question about that? Because it was very confusing from the transcript whether Mr. Daniil was actually interested in, you know, having the ability to hire promoters or use promoters. You know, my understanding, it was all on Zoom and it seemed like there were lots of communication issues people were having and audio issues, but it did seem like he was, I think what he was saying was, I don't really need them. I just want them for the first 2 or 3 weeks or something. Is that accurate? And if so, is it worth fighting over here?
So it's definitely worth fighting over because he hasn't had them or the ability to operate his business and from an unrestricted standpoint. And that was centered around the negotiations when the parties were discussing a potential settlement agreement. And I think it's very interesting, the question that you raise about promoters is because it's not a license endorsement. No permissions required to have promoters. There's no limitation on it whatsoever. It's something that any class of any licensee is able to use. It's
Ask you-
essentially an
you just-
advertising
I
mechanism.
thought you just said he hasn't been able to have promoters, and I didn't read the limitation to be a preclusion on promoters. I thought it was a preclusion on promoters being given certain, to be allowed to do certain kinds of things in promoting, but it was not a flat bar on promoters. Am I misunderstanding the board's order?
I think so. And my understanding of the board's order is essentially that he's not allowed to have promoters unless they're in-house promoters. So a promoter will typically advertise an event at the establishment and run the door, collect the money, and be entitled to some percentage of whatever the income is going to be.
Well, the way, I mean, I'm looking now at the page 10 of the board's order, the 5th of the requirements, which says shall not hire or otherwise allow a promoter or other third party to operate at the establishment. And so I was reading that, but we can hear from the board too about how it understands this order. I didn't understand it as a flat bar promoters as opposed to promoters who did the following, and then it listed things they can't maintain control over the premises by allowing them to, and then it lists 4 things promoters can't do. So I thought you could have promoters. Now, maybe those things, if you can't do those 4 things, you really can't do most of what a promoter could do. I don't know enough about promoting to have any realistic sense of that. But did you read it as a flat bar on promoters, or do you read it instead as a limitation on promoters who maintain control over the premises in any one of the 4 specified ways?
I read it as essentially a factual bar. That's what promoters do for the most part. Now, some of the 4 things are things that promoters are not allowed to do, so it has no impact. For example, maintaining control over the security of the establishment, providing alcoholic beverages. Those are things that can't be delegated. Those are things that the establishment always has to do. But the working the door, collecting the money, distributing the wristbands or stamps are things that promoters would typically do in any relationship with an event that they're promoting at a particular establishment. So we read this as essentially a bar on everything except an in-house promoter, someone who would be hired on payroll, whose job it would be to promote the actual club, and as an employee of the club.
Well, I mean, maybe this is not economically feasible, so you may be right that practically speaking, this is a bar, but at least conceptually, it seems like you could have folks who do a variety of the things that promoters apparently do. But the actual, it has to be the establishment's personnel who are, collecting the fees, checking identifications. It's not obvious to me why that limitation establishment personnel need to do those things would preclude use of promoters otherwise practically. But again, maybe it's true. I have no way of knowing, but it just isn't intuitively obvious to me that those limitations would preclude someone from taking advantage of, I gather, the other kinds of things that promoters can do.
I think that's correct. It goes to the heart of what promoters do for the establishments in terms of running the door and getting people in the door, which is what their job is. And they don't work on as an employee typically would. They are definitely independent contractor relationships. They move around from sort of restaurant, bar or club to club, promoting different events. And I think the testimony, to your Honor's point, from my client was that it's something in his business model that he has used as a starter rather than something that he has used throughout. Obviously, when you have a promoter coming in and taking a percentage of your door revenue, it's a practice that you want to stop doing as soon as it's feasible to stop doing it. So the goal is always to move away from promoters and have the establishment be able to generate income that it's not going to have to share with an outside party.
Can I ask you, is your description of your understanding of or Mr. Daniel's testimony on this topic, is it an implication of what you're saying that you think the board was incorrect as a matter of fact when it said on page 5 of its order, paragraph 16, that Mr. Daniel indicated that the business does not require promoters? Do you think that's a misreading or misunderstanding of your client's?
I do think it's a misunderstanding of what his testimony was. And I think the confusion comes in because unlike an entertainment endorsement or cover charge endorsement, there's no actual legal definition or standard for use of promoters, and it muddles things and makes it more difficult. And I think also with respect to the volume of negotiations that took place between my client and the ANC, trying to come to some kind of a reasonable resolution as to limiting the use of promoters is how that winded up in testimony, as opposed to remaining sort of behind closed doors in negotiation. So I think that's where that concept comes from, the mix between the negotiation piece of these license applications and the actual adjudication.
What was the actual evidence supporting this limitation on use of promoters?
So the only evidence that was on the record, and certainly the only evidence that the board cited to, is an incident that took place in 2011 at a club called Heritage India, which is located outside of the relevant 1,200-foot radius of this particular establishment, that involved the promoter running an event at that particular establishment 12 years prior to hearing that ended in a homicide, I believe, or at least some type of violence that spilled out onto the street. And that testimony came from Mr. Silverstein, who was actually a former board member. And I think probably had something to do with why the board gave that testimony so much credence. But my client had nothing to do with Heritage India in 2011 or at any point thereafter. And it's the distance from my client's establishment makes it outside of the area of consideration. So I think the evidence is flawed a couple of different ways, one being the distance, and two being the time that elapsed, and three being that it had nothing to do with my client.
What about was a relationship shown between the promoters and the violence?
I don't think it was. I know Mr. Silverstein testified. That was his opinion, and I believe he proffered a Washington Post article, which of course we objected to. But I don't think that nexus, or at least not a firm nexus, between the promoter and the actual violence really was ever established. And I think I think in this case, if we look at this and say, oh, well, this violent incident happened outside of the relevant area of 12 years ago, therefore promoters should be limited at this establishment. It gives the board carte blanche to limit use of promoters citywide based on that one incident that took place in 2011.
You keep mentioning that it was outside the 1,200 feet, is it?
Yeah, it's a 1,200-foot radius.
Yeah, so but this is the Heritage India that was on Connecticut south of DuPont Circle, right?
Correct.
You could say it's generally in the neighborhood, or maybe Mr. Silverstein viewed it that way. Does that make it utterly irrelevant if it's outside the 1,200 feet?
I think it does. And the reason why I think it does is because the board has the ability to alter the relevant area. So it can shrink it, or it can make it larger if one of the parties says, hey, these other establishments or these other instances should be considered.
I'm not sure I follow your line of thinking. So for sure, there's the impact, the area, the geographical area with respect to which the board has to assess impact is 1,200 feet here and can be varied. But that seems to me quite distinct from a question of in trying to figure out whether a particular practice is likely to have an impact in that geographical area. Well, let's see what kind of impacts does that practice have elsewhere in the city. So if let's say that no one had ever had a particular kind of establishment in a 1,200-foot area, and the parties and the board are trying to figure out, well, what is the impact of doing a particular thing going to be in that area? Well, we don't have any data in that area because it's never been done in that area. But let's say all over the city it's been done, and there's lots of information about, well, when you do that, here are the kinds of things that happen. Why wouldn't that all be relevant wherever it was located? I don't see the connection.
No, I understand. I think that's a great question. I think they are related but separate issues, and I think it's sort of analogous to considering case law outside of the jurisdiction. The law with respect to alcohol licensing is very area specific, and it talks about unique character of a particular area, and it's this 1,200-foot radius that is the relevant portion. So I think as you move outside of that, you're dealing with a different neighborhood. And if you want to say, well, let's see,
you say relevant area, that's not, it's the area that the board is required, again, depending on which size is picked, that the board is required to assess impact in. But I don't know that means that that's the area where the geographical area from which all evidence has to be derived. I keep losing you when you.
No, I understand. I think that is a distinction that can be made, but also a practice will have a different impact in different areas. For example, this particular area that we're considering has 38 licensed establishments, 5 taverns, 2 nightclubs, where south of the circle may be more or less than that, and having a certain practice being used in a different neighborhood, I'm sorry, in a different area can have a different impact. And I think without full evidence on those points.
What if the evidence were, look, promoters have been used in myriad neighborhoods in the District of Columbia where there is greater and lesser density of bars, nightclubs, but there is robust data to show that in every instance that there's promoters have been used, there has been a quantifiable 25% increase in violence inside and immediately outside the location. So nothing, no data relevant to this particular location or within the geographic boundaries that you have identified, but across the city, regardless of demographics, robust data showing promoters correlate with increased violence. Why wouldn't the board be able to look at that information?
So I think if that's the situation we had, which we don't hear, but if we had
That's
that,
just my hypothetical. I'm just trying to-
absolutely understand completely. And I think if it's a citywide issue that's promoters equal violence, that falls directly within the board's sphere of regulatory authority. This practice is a problem. We want to limit it. We want to regulate it. We want to prohibit it, maybe even. That is something they do on a they should be doing on a regulatory level, as opposed to considering on a case by case basis.
So unless there's an actual regulation prohibiting or limiting the use of regulators, you think they cannot consider even that robust data that was in my hypothetical?
Well, so I think they can if there is that link between promoters and violence that goes beyond what we have in this case. If it's a clear-cut 25% increase citywide across the board, and it's applied equally in among the cases, then I think they absolutely can consider it.
Can I ask you, when you were asked about what evidence there was in the record about promoters, you referred to a particular witness and a particular incident. I thought there was some more. I thought there was testimony, pretty general testimony from Mr. Engelman about his organization opposing promoters. And I thought there was also testimony from, I'm not going to necessarily pronounce this correctly, Mr. Reckgauer, who described what I take to be a different incident that involved promoters who were using bullhorns standing outside and the like. So I thought there were the evidence relating to promoters was somewhat more extensive than the single witness you referred to.
Yeah, Mr. Reckgauer did testify about an incident of noise involving a promoted event in 2005. And I believe that was at Marrakesh.
Well, you described that as an incident about noise. And again, depending on what inferences you think could reasonably be drawn,
Yeah.
Mr. Reckgauer described promoters using bullhorns, but described the incident more generally as involving long lines of people outside and violence. So there seemed like at least he was connecting, whether fairly or reasonably or not, one could debate, but he was connecting it not just to noise, but to problems that ran beyond noise.
I think he was connecting a promoted event, whether or not it was directly related to the promoter or whatever practices were in place at the time. I think he was saying, yes, this promoted event in 2005, resulted in these adverse impacts. And, you have a lot of continuity there in DuPont Circle in terms of the ANC and the DuPont Circle Citizens Association. And over the course of 15 years, it seems that they were able to come up with 2 instances where promoters had events that had some ill effects. I think we could stand that on its head and make it look pretty good for my client's challenge of the restriction on the use of promoters. That is a pretty low percentage in terms of what effect a promoter might actually have. And certainly I don't think there was anything on the record that draws a straight line from use of promoters to my client's practices at all. These we're dealing with unrelated, far out in time instances of conduct that were testified to. So as I mentioned at the outset, there were 5 limitations on the restrictions that we were challenging. One of them was use of promoters. The other is a live music restriction, cover charge, hours restriction, and MPD reimbursable detail requirement. And the basis for our challenge is that the board's conclusions do not logically flow from the facts, and the conditions imposed don't bear a relationship to the board's cited concerns. And I think the big focus of our argument, or certainly the big focus of the board's concern in their order, was the operation of another establishment that is owned by my client, specifically Secret Lounge. And what the ANC raised, and the board spent a lot of time in its order, was going through 3 incidents that occurred over the course of a few years, involving alleged wrongful conduct by Mr. Daniil in the operations of Secret Lounge. And again, we have a similar situation to what you were discussing, Judge McLeese, about Secret Lounge being outside of this 1,200-foot
But is it
area.
your argument still that that makes all of this evidence utterly irrelevant? Because it does seem relevant to someone who doesn't deal with this sort of thing that often, that we're looking at an application from someone for a license in a restaurant and nightclub kind of situation that's going to have an occupancy higher than the Secret Lounge. And, I mean, you can argue about how much the facts and the witnesses sort of support that the Secret Lounge looks really bad for your client. Like the one officer, I think, ultimately admits that it's a good thing to close the door if there's a shooting outside to protect the people who are inside. But to say that it's not relevant at all strikes me as perplexing.
I understand, Judge Beckwith, and I think that's one of 2 arguments we make on that point. Obviously, we lost on that, and let me get to the crux of what I think is really important about this. And of course, we filed a motion and we made the argument that it can't be considered at all. We lost on that, and the board said, well, there's some relevance here, we're going to consider it. What the second piece of our argument, which I think is really important, is if the board is going to consider it as they did, they can't take action based on those instances of conduct that's contrary to the action that they took at the time they actually considered those instances of conduct. So we have 3 instances, 2 in 2018, 1 in 2020, all were brought to the board in some way or another. The first 2 in 2018 for full-blown fact-finding hearings. So what that means is an investigator submitted an investigative report. The board considered the investigative report, and the board said, gee, we really want to know more about this. They called in Officer O'Shea, they called in the investigator, they called in Mr. Daniil, they had a full hearing on it. And following that hearing, they could have taken 3 actions. 1, no further action, we're not going to do anything about this, nothing to see here, essentially. 2, we think the alcohol law has been violated, we're going to refer this or show cause to the Office of the Attorney General. Or 3, oh my God, this is so bad, we are going to summarily suspend this license. And of course, the action that they took in all 3 of those instances, as is evident from the investigative history, is they took no action.
Well, is your argument that they should have been bound by their action? They can't act inconsistently or consider evidence that, in a different context and when a different question was being asked, they might have characterized differently, but.
So it's not really an estoppel argument that I'm making. I realize it has some trappings of that and might sound like that a little bit. It's really, how do you reach a different conclusion? You had the opportunity to limit operations or suspend or fine or take some action against Secret Lounge in succession over these 3 years. over these 2 years, and instead you do nothing and sign off on whatever occurred, okay. And I think the Police Lieutenant Merzig testified to this, that just because a violent incident occurs does not make it the fault of the establishment.
Was he the one who also opined on how no violations were noted, or? I mean, was he the one who talked about corruption and?
I don't think he was.
Okay.
I don't think he was.
Can I ask you, you said you're not making a estoppel argument, but your point is that you can't make a different decision. But I'm not quite sure the decisions are the same. The decision in the context of Secret Lounge was there's a particular single incident, and what should we do about that particular single incident? The issue here is, to what extent does that incident, whatever it called for in its own context, to what extent is it relevant, and how does it weigh among a whole set of considerations that the board is considering determining appropriateness, and also the what conditions should appropriately be imposed? Sure. Different decisions. One is focused on a particular establishment and a single act. The other is a whole set of considerations and lots of different evidence. And so, whatever decision was made when it was a single decision about a different entity and what to do about a single act, I don't see how it's the same to take it into account as part of figuring out what's appropriate with respect to a different establishment.
Sure. So a couple of things. One, I think the board hung their hat on it. I mean, I don't think it's appropriate to look at the order and say, well, they just took it into consideration among a number of other factors. These were the factors. The board said a nightclub here is not inappropriate. Paragraph 36 of the order. They're saying Mr. Daniil running a nightclub is the problem. And it's a problem because of these 3 incidents, 1, 2, 3. So I think.
Well, I thought it was a problem because of noise concerns, and I thought it was a problem for a variety of reasons.
Well, I think it's those 3 incidents and the noise consideration that we haven't really had the opportunity to discuss yet, but I'm hoping that we have time to do that. So, assuming that it's relevant, I think the other important consideration is that a fact finding, when the board is making a determination whether or not they're going to summarily suspend or submit for show cause, what their inquiry is whether this particular establishment can operate without being a danger to the public health or safety. And I think that is akin to the decision that they're making here a couple of years after considering these 3 incidents, that they're going to limit the operations of Signature Lounge a mile or 2 away from here based on the incidents that occurred a couple of years ago. With the intervening timeline, there being no violations. So from 2020 forward, no violations at all at either establishment.
You're saying it's not an estoppel argument, but it is in the nature of sort of a cap on how much they can weigh this evidence. Is that sort of what you're saying? Like if these incidents at the Secret Lounge didn't rise to the level of any of these 3 responses, these graduated responses, how could it possibly, in this context, justify or serve as substantial evidence to support restrictions here?
I do think and the way I think of it is as a lens. How are you viewing these incidents? If at the time you view them, you say this is not that big of a deal, and then 2 years later you say, oh my God, this is such a big deal. We have to take this extreme measure of limiting the hours of operation of this other establishment that is in a different neighborhood than Secret Lounge. And I think the other context that's important here, and some of the testimony that we got from MPD, was that the neighborhood that Secret Lounge is in has 70 plus establishments in that same 1,200-foot radius, whereas for Signature Lounge, it's 38. So you're dealing with a much more, and I think Lieutenant Merzig's testimony on that sort of highlighted what an issue that 9th and U Street corridor is in terms of crowds, in terms of noise, in terms of on-street issues, violence, and other establishments located in close proximity and all the problems that come along with it.
Mr. Bianco, you said you wanted, we've used up all your time, but you said you wanted to get to the noise issue,
Yeah.
and I know the board, I think your argument is that they didn't really explain why the methods that your client tested, or Mr. Daniil.
Mr. Daniel, yes.
Daniil testified he had done to, to eliminate the noise issue or reduce the problem. They don't really explain why that wasn't enough. And then on the other side of the ledger is the non-expert witness who's talking about things that happened a long time ago. But why isn't this really a burden question? Couldn't the board reasonably say your client didn't persuade us that there won't be a noise problem here?
Well, I don't think it is. I think the board's authority to regulate in the area of noise is limited. It's limited to DC Code 25725, which specifically sets forth that or specifically sets forth a pretty bright line standard, which is that in a building that is not the licensed establishment, okay, you can't be able to hear amplified sound from the licensed establishment. Okay, that's essentially what 25725 says, but there's an exception. And what the exception is if the building lies within a commercial, mixed use, or manufacturing zone, 25725 does not apply. So what we're dealing with here is two abutting commercial properties in a mixed use zone, per the investigator's report, where a third floor tenant in the abutting commercial property says, hey, a few years ago, or I guess more specifically, the owner says his tenant told him a few years ago, the predecessor establishment, I was able to hear music. And in response to that, what my client did was took measures to remove speakers from the second floor of his establishment, now being the owner, which is the closest to that third floor apartment. And if we look at the regulatory scheme with respect to noise outside of ABC, you'd look to Title 20 of DCMR Chapter 17. It sets forth very specific noise standards.
Can I ask you, it's a
to be
premise
measured by
of what you're
DCMR.
saying now
Yeah.
and what you said a minute ago, that when the board is conducting its appropriateness inquiry, if I'm understanding the gist of your argument, and the board starts thinking about noise and appropriateness of noise, it seemed as though your argument is noise can be a concern that the board relies upon in making its decisions only if that noise itself constitutes a violation of 725 or maybe also these other regulations. Is that your theory? And if so, why do you think that's the case? Because it isn't at least immediately obvious to me from the statutory language that that's the case.
Not exactly. So my argument isn't that they could, their authority to find violations is limited to 25725. And I think the case law out there, and the name of the case escapes me at the moment, is they can consider noise outside of the context of 25725. But what my point is that what they're considering is noise that would fall within the scope of 25725 is contemplated by 25725, and 25725 says that type of noise is exempt. So that's the evidence that they came in with. They didn't come in with the person across the street saying I could hear them in my apartment, or the person down the street saying I had X, Y, and Z noise issues. They came in with guy in a budding building hears noise, but the statute contemplates that guy in a budding building is going to hear noise.
And is it right to say that if you're correct that there's insubstantial or not substantial evidence on this noise question, that just goes to the prohibition on the live music? Is that correct?
Well, I think, and that's another thing that I'm having sort of difficulty in drawing a straight line from the findings and the limitations. So limiting live music, I suppose, is targeted at that particular issue, but I don't know that you could draw a distinction between the volume of recorded music versus the volume of
Well,
live
I think
music.
the comment was you can adjust the recorded music.
Sure, you can adjust the recorded music, not necessarily the voices that go along with it.
I assume noise also, again, I'm not to say that this is explicitly spelled out necessarily in the board's reasoning, but I assume, at least in theory, some of the noise concerns seem less, well, the noise concerns seem not only about the volume at which music might be being played inside, but also what's going on outside. And you might think that live bands, bigger crowds, more noise external to the, on the outside of the establishment. So there are other possible connections, it seems like.
I think there might be. I mean, it's certainly not spelled out. And that's where I think I have a lot of difficulty here is it's not spelled out. So the board says, you didn't prove to us that you soundproofed the building. And that's not something that is required anywhere in the regulations or the statutes or anything else. And to me, if you're saying we didn't prove to you that we soundproofed the building, the straight line remedy would be soundproof the building, as opposed to saying, well, you can't operate for an extra hour, or you're not allowed to have live music, or something that's much grayer than we identified a problem that you have, which they haven't previously mandated as a standard, and then faulted us for not presenting evidence on that point. And even though we did present evidence with respect to sound mitigation, they then come back and say, no, that's not enough, which raises the question of, okay, then, well, what is enough? It's not like there's a precedent they're pointing to saying you have to do sound reducing panels, or you have to do take these other measures into consideration. And there was some legislation kicking around that I don't think ever made it about neighboring buildings or new construction buildings, certainly, and sound mitigation measures for quote unquote nightclub districts or entertainment districts or something to that effect. Never made it. Would have given us a bright line standard.
I'm not sure that this question is teed up in this case, or do you concede that wrapped up that I think you understand or you agree that it's your burden to demonstrate that you're entitled to the license? Do you think that it's encompassed in that burden to demonstrate that you're entitled to the license free of any restrictions? Or do you think that the burden shifts if you're entitled to the license, but then restrictions are imposed? Is it the opposition's burden to demonstrate the need for the restrictions?
Again, I don't think that's specifically spelled out. What I would say is where we come forward with some evidence on a point, I think the burden at that point would have to shift for the protestants to show a need. In the absence of evidence, I think I would agree with you. If we put forward no evidence on a certain point, that burden lies with us if we didn't make it. But I think at least when we're talking about noise here, we certainly did. And the response we got was, no, not good enough. It wasn't a question of, we did X and then neighbor comes back and says, no, I can still hear the music. I think that is a burden question. We said we did this. The response was nothing. I think it's the board's hard pressed to come back and say not good enough in the absence of further information.
That answer seems not entirely tied to the question of the imposition of conditions, and more to the general view that the way the burden should work here is that there's sort of like a burden of production on the applicant, and then if the applicant puts some evidence on a topic, then the burden shifts to the board. I hadn't understood that to be your argument. And I'm just curious whether you're aware of either support in the statutory language, which doesn't seem to create that complex a scheme, or in any of our decisions or decisions of the board for that sort of way of conceiving of the burden that is on an applicant.
Yeah, I know there's not. I can't point to it. All I can say is that the burden is certainly on us to prove appropriateness. And I think where I stumble, and I think where there's a lack of precedent, is where evidence is produced of appropriateness, not rebutted, and then the board coming back saying not good enough. I think that's really where the issue is here.
Okay, thank you very much. We've taken you beyond your time, so we'll hear from opposing counsel now.
Thank you very much, Judge.
Thank you. We'll give you some time on rebuttal.
Good morning, and may it please the court, Lucy Pittman on behalf of the Alcoholic Beverage Control Board. I'm going to get to the various things that were just discussed with the conditions and the noise and secret lounge and promoters, but I first just want to take a moment to kind of put some context on this. It is a situation where there was protest from two groups, the ANC and a citizens association. When there is a protest under the statute, that means that there is a burden on the applicant to establish appropriateness. Had there not been one, the presumption would have been that it was appropriate. And this was a close case as to whether or not the applicant met his burden here. 2 of the 5 members of the board would have denied outright the license. The 3 members, that the majority that voted for it, did so by recognizing that some conditions in place would help address the appropriateness. Specifically, those conditions are designed to ensure that this establishment does not operate like a nightclub, because the testimony from the ANC, the Citizens Association, and the other neighbors were all overwhelmingly that nightclub activities in this specific spot results in noise, litter, and other problems. So I will start, I think where we were kind of leaving off, which was noise, but I do want to, just because that's where you were, unless the court wants to direct me otherwise. I'm going to start with noise because that is where we had credited testimony from the neighbor who has both a building, a business, as well as he had an apartment next door. This is Mr. McGlade, who testified in detail that the establishment that was there previously, that operated like a restaurant and was fine until it started to operate like a nightclub. And once it started to operate like a nightclub, using promoters, so this is other testimony that relates to promoters, that when it started to use promoters and operate like a nightclub, he started to experience problems both with his business and his residents there, and to the point where he had to move and he had to increase his own staff to deal with security issues. Now, I understand that Mr. Daniel testified that he was trying to mitigate the noise issues by moving speakers, but I think the board is well within its power, and it does have broad power in considering this question, to say that that testimony is insufficient to determine whether or not the noise will be sufficiently dealt with.
What is your response to Mr. Bianco's argument about DC Code 25725 and the standard created there?
Sure. I disagree with counsel that 725 limits the board's power in any way on considering noise. And I think this court in footnote 12 in the Panatet case also said that in that particular context, it was in a heavy commercial zoned area. And this court said it was right when you're considering peace, order, and quiet is right there in the appropriateness standard to consider noise and to consider the noise on the residential areas, despite it being a commercially zoned area. I think the court's decision last week from Conrad on the similar litter provision, also saying that it's not limited to 726, I think is also, I think shows that the board has broad authority to consider the effects of an establishment and is not so limited by that statutory.
And what about
language.
the argument that even if this is true, why shouldn't the condition be your establishment has to be soundproofed rather than no live music?
Sure. I mean, they certainly indicate that soundproofing is something that they could do, and nothing prevents Signature Lounge from coming back and asking to have the condition lifted if they have additional evidence, like they've done some soundproofing. I found it interesting. The example I kept thinking of when I prepped was this would be a different case had Mr. Denali moved the speakers, turned the music up, gone next door and tested it out himself with Mr. McGlade. We don't have that. All we have is that he moved speakers and we don't know, and the board did not know, would that be effective?
Like that would have probably not been with a live band.
Well,
it does seem like the distinction,
insufficient.
the distinction between the live music and the DJs seems arbitrary to me. It seems like the establishment could tell the DJ, keep your speaker to 11, and could say the same thing to the live musicians, no?
I think the board is in its discretion to say that based on its experience that live bands are harder to control the volume, and they think that it might be easier. Specifically where you've got the board telling this new license owner that I assume will want to have renewals in the future. You need to make sure that you control noise, and we're expecting you to do that when it's recorded or a DJ. We know that it's harder to do it with a live band and to not include the live band. I don't know.
Did the board say that in its experience, it was harder to do it with a live band than it was with a DJ?
No, what I'm basing that off of is the board's explanation when it says that the volume control is easier with a DJ or recorded music than it is with a live band.
I guess I'm still not understanding, like the DJ presumably, I mean, I don't know, maybe is an employee, but my understanding is DJs can also be freelancers and can be hired just like bands. So where's the control over the DJ versus the band?
I think both have volume controls. I think bands, yes, you do have amps and things like
This just
that.
gets to my
understand that.
arbitrariness, right? I mean, a DJ is going to show up with all his equipment, right? And my understanding is DJs come with lots of stuff, right? And I just don't see why one would say, oh, we can't have live music because of noise, because we can't control that noise, but DJs are totally fine. It just seems arbitrary. And I don't see a distinction really spelled out as to where the control comes from.
So I would just push back to say, I don't think it is arbitrary. The board, when it is issuing conditions, it has broad power to do so. Its limitations are that it's supposed to explain how it would be in the best interest. It did so here by saying that they think that using a live band would have more difficulty with volume control. You know, if it's possible that's true, that DJs might also be too loud, that might be something that will have to be dealt with at a renewal or at a violations hearing. But I think the board adequately explained how they think this is in the best interest of this community.
Was there evidence to support that explanation? So the board may well have expertise that runs beyond ours on that topic, but ordinarily, you would want the board's expression of views about which it has expertise to be tied to some evidence in the record that related to it. And so was there some evidence about the difference between DJs and bands and live bands and the ability to control volume and the like, or is that really just the board imposing a condition based on expertise it may have gained from other records, but not supported by evidence in this record? And if it's the latter, is that an issue in your view, or is that just no problem?
Sure. So I don't know that there was testimony specifically on live bands being louder, other than with regard to some of the promoted events that had live bands were certainly areas where there was more noise. I think in this context, where you have the question of what evidence is there to say that live bands would be more difficult or would be louder than other music. I think you also have the additional problem of there's no evidence from the applicant about sort of how he plans on controlling the sound with live bands. We do have that he moved the speakers. That would not be the amps that a live band would bring in. And so the absence of evidence there is also, I think, on the applicant as much as it is on protest ends.
I think I'm getting the drift of an aspect of your response. I just want to make sure I'm getting
Sure.
it accurately. Is your point, well, maybe it's true that there wasn't much support for the board's optimism about the ability to control DJ volume, but there was evidence in the record about noise related to live bands, and therefore to the extent I mean, there's not a complaint right now about authorizing DJ music. And if is your point partly, well, you know, whether that's true or not true, that there wasn't much support for the idea of permitting DJ music, there was support at least for excluding live bands. That seems like it's an aspect of what you're saying. I just want to make sure that I'm getting that drift correctly. Certainly.
I mean, that is, I think, when you look at Mr. McGlade's testimony, Mr. Silverstein's testimony, Mr. Ruckgeier's testimony, I also might be getting that incorrect, and Ms. Butler's testimony, you know, they too are describing well, a little less with Ms. Butler, the live bands that come in with promoters are tied to the increased noise in the neighborhood. And so I do think to the extent that there would be an arbitrary sort of argument here, including DJs in that when there wasn't testimony specifically on DJs might be a problem. I'm not sure I would concede outright that it would be, but it might be. But the live bands was included in that testimony and certainly would be within the board's discretion to say that that's something that we want to make sure we eliminate with regard to the noise.
And just one, little point of clarification, when it has a prohibition on live bands, do you understand that to be 2 or more musicians? I mean, a single live musician would be fine.
I don't know, and certainly that hasn't.
A band suggests a collective, right?
It does. It's not something that I considered for this matter, so I don't know that.
It just goes to sort of my arbitrariness. If a single musician could perform live, a single person not being a band, and a DJ could perform.
I would read band as being more than one person, but to the extent that Signature Lounge has a question about that, I think that they certainly could seek that information out from the board or from ABRA to find out. But I too read bands as more than one person.
Can I ask about promoters? First of all, do you understand the board to have flatly precluded the use of promoters?
No, and the board goes out of its way in its decision to say that they are not banning promoters. They are banning 4 specific things that a promoter or a third party cannot do.
And do you have a position one way or another about your opponent's argument that although that may not, to the extent that's not a formal prohibition on promoters, practically speaking, it precludes the typical use of promoters? Do you have a view about that, or is that not something that you think is established in the record and you don't have a view about it?
It's certainly not established in the record. And I would just like to start with, so what the board put in its order on promoters is almost identical to what's in 25-797 of the DC code, which is that you cannot, as a licensed facility, give up ownership or control or operations to a third party or a promoter. They cannot run the security, they cannot run the staff. And obviously the licensed entity with the liquor license has to be the one who actually sells alcohol. That is what 75% of the prohibitions in condition 5 is tied to 797, which is that the security staff has to be run by Signature Lounge. The one thing that isn't also in 797 is the cover charge, although the cover charge is also not permitted by Signature Lounge either. And I would disagree with.
That's a separate condition, not a promoter permission.
That's right. That's right. So Signature Lounge cannot, under I believe condition 3, have a cover charge. And so then under this provision, a third party or promoter also can't have a cover charge. And so they can't kind of get around the no cover charge aspect by having it done by a third party or
that's just the word cover charge isn't used, but that's condition number 1.
That's right.
Under restriction number 5, and that is about collecting admission fees or money from patrons. Is that what you, is that
that's what I'm referring to? And so that too, I would also like to point out, while it's also consistent with condition 3, and I would disagree with my opponent that he did not brief objections to conditions 1 through 4. And so I don't believe that they're part of the appeal, and he certainly didn't bring them up in the reply. But so that is consistent with that, but it's also consistent with Mr. Daniel's testimony. He explicitly states at JA 205 that he has no intention of having a promoter charge an admission at the door, or that he would give a percentage of his fees to a promoter.
Can I ask you, I got thrown when you were connecting the promoter restrictions with the cover charge. So I'm just trying to make sure I understand that. I hadn't really understood the first of the promoter conditions as flatly precluding a cover charge, although practically maybe. It says you can't, the promoters can't collect admission at the premises or in the sidewalk area immediately outside the premises. It doesn't seem to preclude like prepaid cover charges or any of that. So it didn't seem to me, it seemed to me I wasn't connecting that with a cover charge restriction. So maybe I'm missing the practical reality or something else.
Sure, I actually do think as written, it isn't as restrictive as condition 3, because I agree with you. I do think you could have a promoted event with advanced ticket sales. You just can't do that collection at the door. And that again, in direct, is a direct response to Mr. McGlade's testimony. I apologize to him for the fact that he said that when Bistro had promoted events, there were long lines at the door. And crowds and other things. And so I think that that condition goes directly to that, which is to try to avoid having those long lines of people paying an admissions fee.
Could I ask you about, you have drawn a connection between that aspect of the four promoter restrictions. And that some evidence that was in front of the board. But I guess what I found at least arguably missing was a part of the board's decision itself, where the board says, oh, by the way, here is, to use your adversary's terminology, that's kind of through line between the evidence and the condition. So I didn't really see a place where the board says, okay, we've got this evidence about promoters. Here's what it is. We're going to impose these conditions, and here is why. Here is how those conditions relate to the evidence that we had. I didn't really see that anywhere expressly in the board's decision. Is there a place where I'm missing it, or do you think it doesn't matter if it's not there?
So I think it's definitely in the findings of fact. And again, I would push back on his reading of the board's report as well as the evidence on promoters. The board's report, or the board's decision, does reflect that at least 3 witnesses testified about promoters. And it was more than just 1 or 2 promoted events. There's, by my count, at least 5 referenced, and I don't know that in
you're talking about reference in the board's order, or that there was
now I'm talking about the evidence itself, but they do reference for all of those witnesses that they talked about promoted events and the negative consequences of those promoted events. They're in Mr. Silverstein's and Mr. Ruckgeier's testimony that both of them talked about these promoted events and the negative consequences.
I just don't remember, for example, Mr. McGlade, when the board, just apropos of one comment you just made, that the board each time referred to the witnesses as having been testified about promoted events. I did not see that in the board's description of Mr. McGlade's testimony.
That was going to be the place I was going next. They didn't specifically reference it with Mr. McGlade, although that was his testimony about what happened at Bistro. There, the board more focused on the other nightclub activities that people was focused on. But we do have, and we do need to remember that the burden is not on the protestants to establish that this place is not appropriate. It is on the burden is on the applicant to approve that, to establish that it is appropriate. That they've testified that other places that have a tavern or restaurant license that later became more like nightclubs and used promoted events on the night of promoted events would be noise, trash, and violence.
And this is, I mean, that's all a description of the evidence, and you may be winding up towards a more direct answer to the specific concern I had, which is where, if anywhere, does the board say, okay, that, kind of say, okay, here's why, here are the conditions we're going to impose. We're not banning promoted events. There's testimony that problems are associated or correlated with promoted events, but the board isn't banning them. So the board's allowing them, but imposing some conditions. And just, I'm wondering where, if anywhere, the board says, okay, we're not banning them. We're going to allow them under certain conditions. Here's why those conditions make sense in light of the evidence that we had.
Sure. So they make reference to those promoted events in the 2 summaries of testimony that I've mentioned, and they refer to those as nightclub activities. You then find in the conclusions of law that that is what these conditions are designed, with minor exceptions. Most of those 5 conditions are designed to prevent nightclub activities. And I think the 5th condition in particular, by saying that we're going to reduce the sort of the role of promoters at this particular establishment, goes directly to trying to eliminate nightclub activities. I read the board's decision as promoter and nightclub activities kind of going hand in hand. There are other nightclub activities
because they're allowing promoters.
They are allowing promoters, but they're allowing them to a much smaller extent, and also consistent with what is already allowed in statutory law, which is that as long as the license holder is maintaining control over the facility, then a promoter can be used. And that also goes directly to Mr. Ruckhire's testimony, which is they have the problems with promoters when the promoters come in and take over control because they're not trying to be a good neighbor. They're not there for the long term. They're just there, as my opponent said, as an independent contractor for one night. So they don't care if they wreak havoc. But the license holder has to be a good neighbor. They have to come back and get a renewal. And so by putting the onus on the license holder, you can have a promoter, but you must control the establishment. I think is what the board is saying. You can do this, but you must control the situation. Because we're not going to turn it into those chaotic situations where other places have operated like nightclubs, have resulted in noise and violence.
Can I ask, I didn't look in the regulations, but is there a definition of what a nightclub is in the regs? And similarly, a definition of what a promoter is?
I have not found a definition of promoter. The definition of nightclub and tavern are both in statutory law and I believe cited in my brief.
Okay.
One of the bigger differences would be, the entertainment. A nightclub by right can have things that you would otherwise have to get an entertainment endorsement for as a tavern. And there's also a difference in the price of the license and some other, you must have a security plan to be a nightclub as well. You don't need to for a tavern.
If a nightclub is not defined with reference to a promoter, does that undercut your argument at all that nightclub and promoters are being used somewhat interchangeably in this order?
No, not based upon the evidence that was presented in this case, where you have everyone describing that the problem restaurants, problem taverns were the ones that morphed into nightclubs. And
what did they mean factually when they said they morphed into nightclubs versus a bar where music is played?
I would say for almost everyone that used that description, it was the use of promoted events. And so that is why
So they were using it in a non-regulatory way.
I believe that's right. And then as well as when the board members were referring to it, they were referring to it, I think, a little bit of both, because there was a recognition of the entertainment endorsements that were being sought here. So I believe, just to make sure. So I believe I have covered noise promoters and I didn't touch secret lounge. I don't know to what extent the court has any questions specifically about that. I think that the way in which the evidence came in on secret lounge and the way in which the board used it is exactly the way we want the board to handle these things. There are relaxed rules of evidence that this information was relevant. I think that the Panatate case again points out that overlap of ownership does make questions of management and operational decisions relevant. But they also reflected that they didn't give much weight to what is the testimony that 9th Street was otherwise chaotic, because that is not what Connecticut Avenue is. And so I think that the board's opinion or decision here does reflect that it assigned it the appropriate weight.
What is your response to the argument about how they're basically right before this hearing, Secret Lounge was their license was renewed, I believe is what happened, right? And that after the hearings on many of these incidents, nothing really happened. I mean, there weren't, I wouldn't say nothing, but there were no formal violations.
So I don't know that the record is adequate enough on that last part to say what did or didn't happen at Secret Lounge, because I do know that security plans and RDOs and things like that, and so were put in place. And so I don't know that I can answer that part. As for the first part, it's a pretty simple answer. An establishment is considered to be appropriate if there's no protest, and there was no protest for the secret lounge renewal. There was a settlement agreement. The settlement agreement I put in a footnote in my brief, and it does talk about I believe a security plan and using RDOs. And so I wouldn't say that it was without restrictions, but it was through a settlement agreement, and it wasn't protested. So I am way over time, so I apologize. Thank you for your time. We ask that you affirm the board's decision. Thank you.
Thank you very much. Mr. Bianco, we will give you 3 minutes.
Great, just a couple of things. So I guess starting from the last thing first, this notion of the renewal of the license that occurred on the same day, actually, as the hearing in this case, it was by settlement agreement, but the board approves all settlement agreements. They review them for sufficiency. They can reject them. They can modify them. They can impose conditions. They didn't hear it. They issued an order renewing the license based on the conditions in the settlement agreement, none of which were what is at issue here. So again, we have a situation in which we have the board pointing to secret lounge as a problem operation, but then given yet a fourth opportunity to limit the operations of secret lounge, did not. With respect to the board taking no action on the 3 previous violations, just to, I think, clear up what some of the argument was, the board's decision to take no further action in those 3 cases was already in the can, so to speak, when we were at the hearing in this case. And that is part of the record. There is an investigative history for secret lounge that is, I believe, at page 87 of the record. And that investigative history indicates the incidents in 2020 and the 2 incidents in 2018 were considered. Fact-finding hearings were held, and the board took no further action. So we have no further action 18, no further action 18, no further action 20, no further restrictions for the renewal. And again, just to add something that's not on the record, but there was another renewal a week or so ago. Again, no further restrictions on the secret lounge license for those. Once the board had the opportunity to consider those things. The other thing I wanted to just clear up is the notion that we didn't challenge all of the restrictions. That's just not accurate. Our brief specifically addresses each of them in separate subsections. On Judge Easterly's question about the definition of nightclub, we dedicated a fair number of pages in our reply brief dealing with that issue of what is a nightclub defined as, and where did they invent this nightclub activities term from, and does it include promoters? And you know, the brief answer to that is nightclub activities is not defined anywhere in the definition of nightclub. We analyze where nightclub permissions differ from tavern permissions. Starting on page 4 of our reply brief, we talk about those sort of distinctions and how the term nightclub activities is a standard evidently invented for this particular order. The argument with respect to the record on neighbors' testimony about use of promoters, what I would say to address that is the board didn't rely on it. What the board relied on, whatever's on the record, what the board chose to rely on to make its decision is set forth in its finding of fact and conclusions of law. And on those issues with respect to promoters is limited to the testimony of Mr. Silverstein, the former board member, as well as the DCCA's representative, whose name escapes me at the moment. So I've probably used up my time. If the court doesn't have any more questions.
Great. Thank you very much.
Thank you very much, Your
Mr.
Honor.
Bianco and Ms. Pittman, thank you both for your arguments today, and the case will be submitted. Third case on this morning's calendar is number 22 TX 88, District Hospital Partners versus District of Columbia.
Good afternoon, your honors, and thank you. And may it please this honorable court. My name is Kelly C. Miller, and along with my co-counsel, Daniel Walters, we represent the appellant District Hospital Partners. We are here today, and with the court's permission, I would like to reserve 3 minutes of my time for rebuttal. Thank you. We are here today to ask that this court review de novo and reverse and remand this case to the Superior Court for consideration on its merits. In the District of Columbia, when we are faced with a question of whether or not a transaction is taxable, whether or not a certain sale is taxable, and whether that triggers an obligation upon the seller to collect and remit sales tax, we must start at the very beginning of the tax code, the statute itself, section 47 in this case, the gross sales tax statute. And we have to go to the imposition statute. Now, the imposition statute tells us that sales tax is imposed on all vendors for the privilege of selling at retail certain tangible personal property. That's a mouthful, so I'm going to call it items. Except such items where the purpose of the purchaser is to resell the property so transferred in the form in which the same is or is to be received. What is key and critical in this statute is that first, there's the obligation to collect and remit sales tax imposed on a vendor. Second, that sales tax will apply on retail sales of certain items. And third, that sales tax will not apply to sales in which the purpose of the purchaser is to resell the transferred property. Let's frame, I think, some very important facts of this case for the court. Our client, the appellant, District Hospital Partners, operates certain aspects of George Washington University Hospital. And at issue are the pre-prepared patient meals, pre-prepared food trays that are served to patients in the hospital. Now, many of us have had the unfortunate circumstance of having a hospital stay or being with a relative or friend who has had a hospital stay. And we know that those pre-prepared trays that are given to patients, which are often the ire of a stay in a hospital, have a specific purpose. If a patient requires a low sodium and a cardiac care diet, the doctor must order a meal that meets those requirements.
So counsel, I mean, without getting into the details of the actual item being sold or resold, right? And can we go back to the statute? I guess you were reading from 47/2002, is that right? To start, the tax is imposed upon all vendors for the privilege of selling at retail, tangible personal property, and for the privilege of reselling certain services. Is that what you were reading from before?
And that certainly is.
Right. So that's the imposition of tax. But I thought that this case was about interpreting 47/2010.
This case,
am I mistaken about that?
Yes, Judge Easterly, this case certainly involves 47/2010, absolutely the presumption of taxability. But Again, when you're looking at a tax statute, unfortunately, this
You
one,
think we need to start somewhere
I
else?
do.
Okay, was
Fortunately,
that,
we don't have to go
was
back to
that-
the 1700s for
was
this
that
case, but
no, thank goodness for that. Was that made clear in your brief that we start with 47, 2002? I don't,
47, 2001 and 1. And yes, it is. I think we lay out very clearly in our briefing that under the statutory construction of interpretation of tax laws, we can't simply start in the middle of the code.
I guess I just don't quite understand what that gets you, starting there. I mean, because then you go to 2010 and it says it shall be presumed that all receipts from the sale of the item, right, are subject to tax until the contrary is established. And the burden of proving that a receipt is not taxable hereunder shall be on the vendor or the purchaser as the case may be. Right? And so you stand here as the purchaser, I take it, right?
Absolutely. Yes, as the case may be.
Sodexo is the vendor. In this
Correct.
instance, you all are the purchaser. And then it says, except as provided in 47, 2005 subsection 3, which no one is arguing pertains. Unless the vendor shall have taken from the purchaser, so unless Sodexo shall have taken from District Hospital Partners a certificate signed by and bearing the name and address of the purchaser and the number of his registration certificate to the effect that the item purchased is exempt, the receipts from all sales shall be deemed taxable. And I understand that there was no certificate of resale and that it wasn't presented at the time that you purchased these items from Sodexo. So the case seems pretty straightforward to me.
Well, Judge Easterly, I thank you for your question and I appreciate your recitation of the statute 47, 2010. I want to go to the very first line. And the very first line says, it shall be presumed that all receipts from the sale of tangible personal property and services mentioned in this chapter. So when I read the statute, I think about, well, what do we talk about when we talk about the sale of tangible personal property? I need to think about how is TPP, tangible personal property, what I've called items in this case, defined, and where do we turn in the statute for that guidance? And that guidance is irrefutably provided in 47, 2001 and 1 definitions. So in construing a tax statute, I would say that in any provision under section 47, we must, Judge Easterly, go to the definitions that are relevant at issue. And if we look at 47, 2001 and 1, that is the section that defines the terms retail sale and sale at retail.
Can I ask you, I follow your line of thinking, I believe, and I take the upshot of your introduction to be, if it weren't for 47, 2010, you would win this case. And I don't think that's even disputed. So I think that other provisions of tax law would entitle you to prevail. There may be some residual factual question, and so maybe there could be a factual dispute about something, but you may well be right that you would win, but for this provision. But to the extent I understand the point you were just making, it keyed in on the first sentence and seemed to start trying to get into definitions of sale of tangible personal property and the like. But the provisions that seem most difficult for you to address don't seem to have those any word other than sale. Now, maybe the word sale has a definition that's restricted too, but the provision, like the last two sentences, the accept clause says, basically paraphrasing, unless you get a certificate, the receipts from all sales shall be deemed taxable. So I don't, to the extent that the presumption sentence earlier, which I don't think necessarily is directly at play here, might have narrower terms that would allow for some wiggle room. I didn't quite see that in the provision that seems most directly, one of the two provisions, the next sentence also is important on timing. So do you think that the accept sentence that we've been discussing applies to all sales? And if not, why not?
Meaning, excuse me, Judge McLeese, you're referring to accept as provided in 47. Okay. So I think that taxation of any transaction depends on the nature of the transaction itself.
that's hard to dispute and very abstract. So and maybe you're going to eventually get to an answer to the question I'm asking, but that's, that seems fair enough. But under this provision,
Yes,
do you think that the provision, the
acceptable.
language that says, unless you can meet a certain exception, the receipts from all sales shall be deemed taxable. Do you think that language applies to all sales, or do you think it applies only to some subset of sales?
I think it applies to all sales so long as they are taxable under the statute. And the statute clearly provides an exception for sales for resale.
Well, I guess what's a puzzle is if it doesn't deem if that provision doesn't deem taxable something that otherwise would have been non-taxable, it's a superfluity, right? I mean, it seems to say every sale, you know, if you just, again, if you start here, and I know you don't want to start here, and I think you probably have to go start both places, end in the middle and see where you end up. But if you start here, it seems to say every sale in the District of Columbia is deemed taxable unless.
Sure.
And so it seems to create like a presumption of taxability. Now, maybe that's overbroad because you could say, well, there are lots of other exceptions, and so you can't really read it that way. But in any event, where I got hung up was to the extent you're going to pick the first sentence and pick some terms in there that are narrower than the word sale and start trying to, develop theories about what that means about the scope of the presumption. That seemed a little bit off the center of the provisions that don't seem to have that feature.
Thank you, Judge McLeese. I appreciate your comment and I appreciate your question. And I think to answer the question that you asked, which was, does this language apply to all sales? I do maintain it applies to all sales that are taxable, but let's assume in arguendo it applies to all sales. And let's assume under your—
Before you go that way, so if that's your position, it seems to me that what you think the provision says, unless a certain thing is true, all taxable sales will be deemed taxable. Because if you think it only applies to taxable sales, then this is it says, unless a thing is true, all taxable sales shall be deemed taxable. That seems, a very long-winded way of saying nothing.
Okay.
And strange way of saying nothing, because if you're going to say something circular, you wouldn't normally make it dependent on some other condition. So it's like a conditional circularity. It seems like a very counterintuitive reading.
I wouldn't necessarily agree, but may I be permitted, Your Honor, to respond to your point about if 47-2010 didn't exist, we wouldn't be here. Because I do think that is an excellent point. I'd like to respond to it, if Your Honor will allow.
Of course.
Thank you. So again, I would like to refer to the end of the statute. The certificate herein required shall be in such form as the mayor shall prescribe, and in case no certificate is furnished or obtained prior to the time the sale is consummated, the tax shall apply to the gross receipts thereof, as if the sale were made at retail. Again, this statute, right, presumes that there has to be a form, and the presence or absence of a form determines taxability. It doesn't. And the reason, Your Honor, why I've focused on the statutes in the balance of Section 47, which I think need to be read in concert, and I appreciate your analogy of sort of coming at this again from both sides to the middle, is that 47-2001 specifically refers to the purpose of the purchaser to resell the property. That is the qualifying moment. That is the essential question. Is the purpose of the purchaser to resell the property? This statute, 2020, requires there to be a form in order to determine taxability. And I posit that we cannot make a determination of taxability dependent upon the absence or presence of a form. This statute says the form has to be provided before or at the time of sale, or there will be an impermissible bar for any taxpayer to overcome. It is—
Can I ask you, why can't we do that? Just you seem to think it's like fundamentally it couldn't be right. And I just want to make sure, and I mean, I'm not a tax lawyer or anything close to it.
Sure.
So you may well be right, but I just, I want to see if I can get a little more of an explanation about why it seems, impossible to you that the legislature could have said, we want to tax a particular kind of transaction. So we're going to define it substantively, but we're going to create a process. And if the process isn't followed, we're going to say, we're not going to look under the failure to follow the process to figure out what the economic reality was. We're going to stick with a requirement about, following a procedure, proving a thing up at the relevant time, rather than trying to reconstruct it after the fact. That doesn't seem to me to be, that doesn't seem to me the only way to handle these situations, and there are other jurisdictions, for example, handle it differently. But that seems like not a facially implausible or unreasonable one. So if a thesis of your argument is, look, that you just can't understand a tax code that way, I would need some more explanation to accept that idea.
I think Judge McLeese putting the question of whether or not a transaction is taxable based on the presence or absence of a form, and it had to have occurred at one specific time in a transaction is really, and I will borrow your words, an unduly restrictive standard. Because fundamental to our tax code and fundamental to our statute under Chapter 47 is the right of a taxpayer to a refund. Right? This is a right of due process to every taxpayer. We file our tax returns each year. If we discover that we have erroneously paid tax, then we are entitled within a statutory period that's limited. It's not an unlimited period of time for making a claim for refund, but we're allowed a period of time to make a claim for refund. Now imagine the resale certificate in this case being imposed in such a duly restrictive manner. I spoke about the trays. I won't belabor it out of respect for the point raised by Judge Easterly. But again, let's say there are trays being sold to the hospital for different patients and different diets, and they're on different purchase orders, okay? Under the standard for resale certificate in the district, every purchase order must have a resale certificate. Sodexo pulls up to GW Hospital. They have patients that are in need of meals. They deliver 10 orders of 100 trays each for each specific patient diet. Order 9 was missing the resale certificate. Is there any doubt? Think about this. Is there any doubt as to the purpose of the purchaser here? Absolutely not. None of us would walk into
But the district has to deal with millions of transactions. And I guess I don't see the point. I mean, I take your point that the existence or not of the certificate doesn't dictate whether or not the transaction is taxable, right? Like, so you could show the certificate and pay the tax accidentally and then say, oh, but wait, we want the refund because we showed the certificate. Fine.
Yeah.
Right? Yeah. Because showing the certificate is a necessary obligation, but isn't sufficient, right? So it could be the flip that you show the certificate, but actually you're not reselling, right? So you're committing fraud.
That's right.
They could do an audit, right? But I don't see what the problem is with the district saying we have millions of sales happening in the District of Columbia. If you want to evade sales tax, if you don't want to collect it, have the certificate and have it ready. And presumably there's lots of paperwork that happens with these meals being delivered, just like there are lots of other paperwork that has to be filled. I mean, I'm not finding that to be a compelling argument. This seems like, as Judge McLeese was indicating, like a totally reasonable way of running the railroad.
Well, Judge Easterly, to your point of if you have the certificate in hand, you've signed it, and it is under oath, so one would hope that it's signed validly, you would be exempt from tax, right? Not evade, but exempt from paying the sales tax. And the district raises this argument, which is time and true of taxing jurisdictions. If we allow this, the floodgates will open, will be overcome by claims for refund. That is an essential part of due process in our taxation system. No taxpayer in the District of Columbia, no individual, and any taxpayer should be required to pay more tax than they are legally obligated to pay under the relevant statutes.
Although I thought you concede that even with respect to refunds from corporations or individuals who are paying income tax, for example, that sometimes you could be. Let's say I overpay my taxes and the time period in which to recoup them runs. So I don't know what that time period is, maybe it's 3 years. If it runs, then I can come in and I could say,
that's absolutely right.
No taxpayer should be required to overpay. I'm being required to overpay. And what the district, I assume, would say, and I think, I gather you would agree lawfully could say is, no, there was a time and a place to raise that claim and you waited too long. And so it's not a fundamental due process right to always have a redo and always have the amount of taxation paid reflect the, ground truth. Do you agree with that, or do you disagree? Do you think it's a fundamental right to always get a redo, no matter what the procedures are in the local jurisdiction about how they're going to allow tax liability to be established and processed?
Oh, I do, Judge McLeese, and it's because this unduly restrictive standard of requiring a certificate at the time of sale.
Can I ask you, so
Yes.
I just want to clarify what you said when you said I do. You agree that there's not an absolute right to always get into court and say, I didn't follow the relevant procedures, I didn't do things at the relevant time, but the truth is I didn't know those taxes. You don't think there's an absolute right to always do that? Your point, is that correct? You don't think that's an absolute right?
I don't know if whether I do or don't think that has a bearing on the issue here before the court in terms of whether or not this determining taxability by the presence or absence of a form is appropriate.
So you're taking the fifth on that one, or
Well,
okay, fine.
and that's the issue before this.
Well, no, I think the issue, part of the issue is if you, if today one of the things you said, if I understood, heard it correctly, was a taxpayer always has a right to only pay the taxes the taxpayer is required by law to pay. If that's a sentence that you're uttering, then it seems to me that if that's part of your argument, it would be relevant to answer the question of whether that's really an absolute right, or whether there are circumstances in which a jurisdiction can say, well, you had that right at some point, but you didn't pursue it in the way that the law requires. And I mean, if your position is nope, you can always come back, and any law that has like a statute of limitations on refunds is unconstitutional, that's a tough hill to climb. So I take your point, if it's to be, at least in my mind, somewhat plausible, to be, there may be some ability to do that. But what a jurisdiction can't do is do things that are unreasonable and unduly restrictive. And to read this that way would be that. That argument I can understand in the abstract. And then I guess the question is, how unreasonable and unduly restrictive is it? And I just wanted to ask one question about kind of a practical point you were making about all the paperwork and lots of different forms and any, one little thing could go wrong. It's my recollection that the regulations say that if a vendor and a seller have like tons of transactions that are all going to be covered, there can be like a global certificate. Is that, are you familiar with that, or do you?
I don't want to respond to facts that are not.
This is not a question about facts,
Sure.
It's a question about what the regs provide.
Sure, I'm not prepared to speak to that specific regulation at this moment. It very well could exist. I don't recall that specific language at this moment. I just don't want to speak to it without having that language of the regulation in front of me, Your Honor.
So it's hard, if you're not sure whether such global certificates are feasible, it sounds like you also may not be sure how impractical the requirement is here, if it is a kind of a flat rule.
No, Your Honor, I wouldn't go that far. A global certificate was never and has never been an issue in this case.
The question we have in front of us, though, is how to interpret these provisions. And if part of your argument is, no, if you interpret this as being like a flat rule that you can't fight through after the fact, it's unduly burdensome and unreasonable. That's not a question. That's a statutory interpretation question we need to answer generally. It doesn't turn on whether there were global certificates in this case or not. It turns, at least potentially in part, could be relevant to, at least potentially in part, whether there are regulations that bear on the assertion that interpreting the statute that way would be impractical or infeasible.
So I want to unpack some points that you raised, Judge McLeese, and respond to them in turn. I think the first that you raised to me is, Ms. Miller, do you agree that there is, complete right, unfettered right of a taxpayer to seek a refund? And I would never say that. As we know, there are limitations on seeking refunds. What I would want to point out here is when a statute requires a certificate or the absence thereof to determine taxability at the time of the transaction, not later on when we file our tax returns or when we do our monthly or quarterly sales tax returns, but at the time of the transaction, that cuts off the time period. And you've seen the Bellows and the Steubenville cases, and in Ohio, they amended the statute, right, to provide a reasonable period of time for the resale certificate to be provided. That is a key and critical distinction of that case, and it's important to raise to this court. So in answer to your question, do I think that there is an unfettered unilateral right in all cases to seek refund? No, our system would be overburdened by the same. Do I think that legally taxpayers should only have to pay tax they are legally obligated to pay and not more than that? Yes, and that is why suits on overcollection will continue to persist, and why overcollection is a peril of any tax administrative system. To answer your second question, which went to, I believe, Your Honor, this issue of the regulation. I can't speak to the regulation and there being a requirement for, a global, perhaps there is. So, Your Honor, let me assume, again, that there is a regulation that says that there are many types of transactions in between a vendor and a purchaser, they can get one sort of overriding provision. How is that implemented? What is determined to be a like-kind transaction? How is that viewed by the taxing authority? What would be the standard? I think that there has to be a permissive opportunity for the taxpayer, Your Honor, to provide evidentiary support and proof for, and I go back again to 2001 and 1, what is the purpose of the purchaser, right? We're not a district of taxation by gotcha or foot fault. We're based on the statute, right? And fundamentally here, when you think about this transaction, these patient trays prepared by Sodexo brought to the hospital, there's clearly no other purpose of the purchaser but to provide those to patients. In this case, there was tax paid when Sodexo sold those trays to district hospital partners, and then there was tax paid when district hospital partners sold those trays to patients. For any of us who've been in a hospital, you know the bill. The bill has every single Band-Aid and suture and staple that they use. It sure had that tray and it had that tax. And the reason why we cannot let the decision of the Superior Court be affirmed, and we need to remand back for consideration on the merits, is because this is a fundamental right of a taxpayer to not have to be beholden to whether the presence or absence of this resale certificate at the time of the transaction determines taxability, but rather it has to be what is the purpose of the purchaser. Are there any other questions, Your Honors?
Thank you very much.
Thank you for your questions.
We'll give you a little bit of time on rebuttal.
Thank you.
Ms. Barone?
Pardon me, I'm so sorry.
Good afternoon, Your Honors, and may it please the court, Natisha Baranya for the district. I'd like to just start by clarifying one thing about the briefing in this case. Nowhere in this appeal has DHP argued that it should be able to fall back on some sort of absolute right to gain a refund here, nor has it argued that there's any sort of due process concern implicated in this case, at least not on appeal. And so that just hasn't been briefed before this court. And I think that counsel for DHP near the end of the argument sort of disclaimed that there would be any sort of absolute refund right that you could fall back on. But I'd like to start, if I may, by just turning to the text of section 47-2010, because I do think that that section can be dispositive here in this case. And then if time will allow, I'd like to also address the arguments about the application of this New Jersey case that DHP brings up in its reply brief for the first time, as well as the text of the separate refund statute, which again, as I'll explain, isn't really directly at issue here because section 2010 is just so clear. So turning to the text of section 2010, it's important to note that that section states, unless the vendor shall have taken from the purchaser a certificate, the receipts from all sales shall be deemed taxable, and this is the critical language, in case no certificate is furnished or obtained prior to the time the sale is consummated, the tax shall apply as if the sale were made at retail. That language is unambiguous and clear. And to the extent you find any ambiguity in that language, the Expedia case that we cite to in our brief makes clear that the next thing you should turn to here is the legislative history. Now, this provision was enacted back in 1949. It's quite old, but it was substantively amended once. And the one time it was substantively amended was back in 2001. And that's when the council decided that it wanted to expand the strict nature of the certificate requirement and apply it not only to resales, but also to other exemptions listed in section 2005. Now, when it did that, the finance committee of the council, which sort of put together these potential amendments, explained, quote, it wanted to ensure that, quote, any sales tax charged need not be refunded, end quote, in cases where there isn't a certificate provided at the front end. So the text is clear. The legislature made very clear when it amended that text that it wanted to apply it not only to resale certificates, but to all kinds of exemption certificates. And we think that pretty much closes this case. To the extent there's, any ambiguity even then, we'd like to just point out that this is a system that works for everyone. It's understandable that businesses have, in this case, a lot of different trays to give out, and it's hard to keep records of everything. It's even harder for the district to figure out on the back end which trays were entitled to a sales tax exemption and which ones weren't. And that's why the system is designed to ensure that sales tax revenue is predictable. Everyone knows at the time of the sale which sales are entitled to the resale exemption and which ones aren't, so that purchasers and vendors, right when they're making the sale, can sort that out. All the purchaser.
In defense of your opponent's argument, in one respect, the statute is not entirely consistent in reflecting the view that we need to have a definite answer at the time of the transaction, because the district does reserve to itself the ability to unwind transactions that it believes were falsely treated as not retail sales. So it's not symmetrical in that way. It's kind of a the district structures things so that it permits reopening in the district's interest, but is categorical the other way.
That's right. There is some asymmetry there, and that's asymmetry the legislature created in the statute. And there are two reasons why we know that asymmetry exists and is not improper here. The first is that if you look at section 2010, it's worded in the negative. So it ensures that vendors know exactly what to do when a certificate is provided. In that case, they don't have to tax the sale, but it doesn't necessarily say that if even when a certificate is provided, that certificate is sufficient. All we know from section 2010 is that a certificate is necessary. That closes the case here because here everyone agrees no certificate was even offered. But the other reason why that asymmetry is okay here is that that's just how the legislature has chosen to figure out which sales are going to be sales for resales and which ones aren't. That's a difficult choice to make. You can figure that out at multiple different points in the transaction. The easiest way to do it here, and the way that states typically do it, is to ensure that right when the sale is being made, the vendor can sort of help the district figure out what's going on by ensuring that the certificate is being provided in good faith. And so the system is set up to figure out at the front end whether the sales are for resale or not. Now, admittedly, that might lead to some cases where the district wasn't able to catch a sale that wasn't actually resold ultimately. But the council, when it amended the statute, made clear that it's okay with that kind of error, so long as the system is designed to ensure that at least you have to provide the certificate. And in those cases, we're going to tax the sale when you don't have one.
I take your point that there wasn't a full separate due process constitutional argument in this court, as I think there was to a degree in the trial court, although there is a mention in your opponent's brief, at least at one point, of the concept of due process. So it's lurking around a little bit. Leave aside the issue of the question of kind of whether the issue was adequately presented and briefed. It's a kind of a theme of your opponent's argument that interpreting the statute in the way that you advocate is just fundamentally unfair and not reasonable and not unjust, and we shouldn't do it. So do you have a response to that line of argument?
Sure. So I'll provide two responses there. The first is that just when you think about due process, it typically doesn't apply to a case like this, where a taxpayer voluntarily paid a tax on a purchase that it made. It saw that it was being billed for the tax. it paid that tax, and there's a statute that imposes the tax on exactly that kind of sale. So at the time the sale was made, there wasn't, a taking or any sort of other due process concept you could really fit in here, because when the sale was made, everyone agreed that it was a taxable one. I'd also like to note that sort of from a general fairness perspective, we've designed a system that is predictable and accurate for everyone involved. The flip side of what DHP is asking for in terms of consequences is a system where any taxpayer could come back 3 years later, present pages and pages of documents showing what it ended up doing with the purchases it made, and then require the district to use its tax funds to sort through those pages of documents and figure out whether or not it was entitled to an exemption. The exemption is something the district doesn't necessarily have to provide. There's no due process right in a resale exemption. The sales tax is a tax that the district chooses to impose on retail sales, and it can decide how it defines those retail sales. Here, the legislature has defined them to ensure that when there isn't a certificate that the purchaser provides on its own end, then we just assume it's a retail sale. And that's a simple process for everyone involved. It's fair, it's efficient, and it's, again, a one-page form that's fairly easy to comply with.
Because again, the legislature doesn't fully assume that, because that assumption is rebuttable. If there was a certificate, that's a rebuttable. I'm not even sure who has the burden right now, but that's not an irrebuttable presumption. There is the ability to claw that back in one direction. So it might be a bit of an overstatement to say that the system is designed to be, we're going to figure out an answer at the moment of sale, and it's going to be perfectly predictable, and then nobody has to worry about it thereafter. That's not the system that was created. The system was created when, if you don't have the form and you pay the tax, you're out of luck. That's your argument. And on the other hand, if you do have the form, if we can prove that you're not doing right, we can still claw funds.
Right. So to respond to your concern about I guess you could call it the lopsidedness of the system in that way, the reason why it's okay for the district to do that from a just general fairness perspective, again, ties back to the statute. So the way that the legislature taxes retail sales is by taxing based on the purpose of the purchaser. The way we determine what the purpose of the purchaser is by asking the purchaser what kind of purchase it thinks it's making. And how it makes that determination is by providing the certificate. Now, if on the certificate, it says it's going to make a resale and then ends up not reselling, the reason why the district can go back to the purchaser and require it to pay those taxes back is because that's a case in which the certification just wasn't accurate, it wasn't correct. And that's how the tax is designed to work. Now, I realize it might be unfortunate in some cases where a purchaser, slipped on a banana peel, didn't really fill out the form, but then every time that it makes a purchase in the future, it can hand over that one-page form. This isn't a requirement that's made that you have to meet 10 years in advance. You just have to present the form every time you buy some things. So the next time you buy some things, you can hand over the one-page form. If it's all right, I'd like to move to just the New Jersey case that's raised for the first time in DHP's reply brief, since we haven't had a chance to answer that. I'd just like to note that that case isn't really relevant here for two reasons. First, that case involved a statute that isn't like the one the district has here. The statute in the New Jersey case did not contain the critical language unless in case no certificate is furnished or obtained prior to the time the sale is consummated, the tax shall apply. Since the statute didn't exactly say that, the court in that case found it to be a little ambiguous. And so it looked to a separate regulation that the state of New Jersey had interpreting that statute. And that regulation made pretty clear that in the state of New Jersey, even where a certificate is not provided, the purchaser might be able to present some evidence to show that they're entitled to a refund. We don't have a regulation like that in the district. And the reason why we don't is because the statute is pretty clear that that's a taxable sale as soon as you don't provide a certificate. I'll also just quickly note that there's been some discussion of the refund statute and whether that refund statute can sort of apply more broadly to kind of cancel out Section 2010's more precise language. Again, the refund statute only applies when there's an error in the collection of the tax. And so it just brings you right back to the operative provision, which is Section 2010. And that's what tells you that this is a taxable sale. So you can't really use the refund statute to get around the operative definitional provisions that tell you what sales are taxable and which ones are not. If there are no further questions, I would just ask that this court affirm, and thank you for your time.
Thank you very much. We will give you 3 minutes for rebuttal, Ms. Miller.
Thank you, Judge Beckwith. I appreciate the very same. I want to go back to a point, an excellent point raised by Judge Easterly and respond to it since it was raised by my opponent's argument. This is not a case about pages and pages of documents that the district will be overburdened on receipt from taxpayers. Here in this case, the vendor and the purchaser have agreed. That is an undisputed fact in this case. They agree on the purpose of the purchaser in this case and what the purpose of the purchaser was. There is no discrepancy. I then wanted to respond to and to echo Judge McLeese's excellent point about asymmetry in the statute. You're absolutely right, Your Honor. This is the district having a club that they can come in and rewrite how a taxpayer has treated the transaction, and the taxpayer has not been given the opportunity. And we see this in how the statutes were rewritten, right? After we look at the Ohio cases, which I'll refer to in a second, that I think is very important. In a lot of the other cases before the court, the taxpayers at issue, vendors and purchasers did not agree. And in here, we do agree. This is a refund case. We didn't concede anything about it not being a refund case. Recall that the taxpayer paid the tax during the audit, but did not concede the issue, but paid the tax. Why do you want to do that? Because penalties and interest will run on you. Of course, we should allow a taxpayer to pay tax. However, they didn't concede that this tax was erroneous. And that was the nature of the refund claim, which was filed timely and was filed under the statute. We cannot let the district tax us by foot fault. We must have the district tax statute under the statute and legally, because if a purchaser intends, the purpose is to resell the items at the time of the purchase, that transaction meets the exception provided in the imposition statute. And I have to go back and say the reason why we have that exception in the imposition statute, the reason why we start there is very important, because it goes to the intent and the purpose of the purchaser, a point that that the district has conceded and agreed to in arguments here this afternoon. So I just want to say something a little bit about the case, because I think the cases are really important. And I want to hit a little bit of a response, excuse me for me not being speaking not at the podium. I just want to be respectful of the court's time. But I want to talk about Steubenville. I think the Steubenville case is really important because district relies on it in their briefing. And the purpose is clearly within the ambit of the purchaser in that case. And there's a distinction. Because in that case, the vendor was claiming the resale exemption on trucks that were going to be used in the mining production business, right? And interestingly, there was a statute on the books at the time that was a statute that says that if you don't produce the resale certificate, then the sales tax will apply. And after Steubenville, the court instructed the legislature in Ohio that we needed a period of time, a reasonable period of time to allow the taxpayer to remedy. And that's clearly what should be the case here, because again, this is an undue burden. It's unduly restrictive to not give the taxpayer the opportunity to look beyond this moment of the sale. And I would argue that the moment of the sale is a very harsh and bright line rule. Remember here what the result is. The result is that these patient food trays had gross sales tax paid on them, not once, but twice. The district got to double dip on its own accord and its power without giving the taxpayer the opportunity for a refund of erroneous tax paid. And that resulted in patients in this city, residents and citizens of Washington, D.C. paying sales tax on these meals in the hospital where sales tax had already been paid on the same. For all of the reasons that we've presented, both here in court orally today, as well as in our briefings, which we stand on, we ask that this court simply reverse the decision of Superior Court and please remand this case to be considered on its merits. Thank you very much for your consideration.
Thank you very much, Ms. Miller and Ms. Bronia, for your arguments today. We will take this case under advisement and we are adjourned.